Okay, good morning. Good morning, everyone. Welcome to today's hearing on policy-related matters relevant to the proposed Arecleoch wind farm extension. Before we start, can I just get the customary wave or thumbs up, just so as I can check that everyone can hear me okay? Okay, thank you. I won't go through the same introductions and formalities as Alison did yesterday, other than a simple reminder that the hearing's being recorded and will be on our website. When you're not speaking, as Callum said, please have your microphone off, and for anyone just observing, can you ensure you have your camera off now as well, please? Thank you. So we'll have a short break sometime this morning, and then stop for lunch at 12 or soon after. In the afternoon session, we'll have another break, and I'll aim to stop at 4, perhaps somewhat sooner, perhaps somewhat later, depends how we get on. Hopefully, following yesterday's introductory session, there aren't any procedural issues we need to discuss, but you can tell me before we start if there are. And you'll all have seen the agenda. You will have seen a list of documents that we issued last week, and those circulated yesterday by Mr. Kelly and Mr. McDade. Sorry, Ms. McDade, not new documents, but just highlighting, which of the core documents that we may well what need to turn out today, or at least to refer to. So hopefully you can have those to hand, as well as our agenda. Just in preparing yesterday, I noticed there's probably 4 or 5 other documents that I should have put in our list that we might come to and we might refer to. So we'll come on to these later. They're all core documents, but it might be that you take a minute or two to find them if we need to. So we have a few questions in relation to some of the agenda items. For others, we don't have any, but we've included them just to give you a right of reply, if you like, to the hearing statements of the opposing parties. But I do want us all to keep in mind that the purposes of our discussions today need to remain relevant to the determination of this application under the Electricity Act. So I'll move us on to the next point in the agenda. I think we're straying away from that purpose. Ms. McDade, you mentioned Black Start yesterday, and I think you felt that would naturally fall to be discussed after item 7, which is constraints, payments, and contracts for difference. So that seems fine. We can pick it up then. If I forget to do that, just shout out. With all the written evidence before us, we will of course take it into account. So there's no need to repeat today any of that just for the sake of it. But you can, of course, take us to it if that helps you explain at the point you make. And you can ask questions of each other, but we will ask that you do that through us. And we'll give you the chance, before we move on to the next item in the agenda, to confirm that you've said what you wanted to say in each subject, subject to my caveat about relevance. If you do want to come in at a particular point, then just raise your hand. Hopefully either Alison and I will notice that, but we might be taking notes or looking at documents. So if we don't notice you, just speak up. Just before we start then, for the applicant and for the council, we have both an advocate and a witness. I'm just assuming, Ms. Sidgwick and Mr. McGibbon, that I'll address my questions in the first instance to you, and if your advocate wants to come in, then we can deal with it that way. But is that okay? And Ms. Sidgwick, I don't think you were introduced yourself yesterday, so could you say hello? I can't see you on the screen actually. Mr. Ennis, can you help?
Good morning, sir. Yes, thank you. How our system operates here is we don't have 2 people on. We're on a single link, and when Alison Sidgwick is going to speak, I get switched off, and her separate camera gets switched on. And it's one of the ways in which effectively we can participate with more than one party, but on one link, and it therefore saves bandwidth, etc., rather than having a whole group. So that's just the explanation. So I'm here with Alison Sidgwick, and I'm instructed by Lowry Martin of SPR Legal, and we're all in the socially distanced room. But I will now, just so that to demonstrate how it works, I will now hand over to Alison Sidgwick.
Morning. I'm here representing Scottish Power. Stevenson Halliday.
Good morning. I think I'm struggling to hear you. Actually, the volume's very low. I don't. The sound quality is fine. It's just that the volume's very faint. I don't know whether you're able to move the microphone or it's just a question of turning up the volume. It looks like other people are having the same issues just from the reactions. Is it
I think
possible?
that is being done.
Okay, thank you. Okay. Whilst you're doing that, I'll come back to you in a second, Mr. Campbell. Oh, sorry. Well, it's the same question, Mr. Campbell. Is that how do you want to work it?
Well, it was the same question. I could see Mr. Innes and Mr. Sidgwick very well, but well, actually not very well because the figures are tiny in the picture, but they're practically inaudible. I don't know if it's my age or whether Scottish Power can't raise the volume a bit, but I wonder if you could look at that, see if you can do something about it.
Do you want me to test that again? Is that...
That's much better. That's much better, yeah.
Okay, thank you. And Mr. Campbell or Mr. Gibbon, I'm going to put the question in. I'm going to assume that you can answer the questions unless you intervene. Is that okay?
Indeed it is, sir, yes. I mean, Mr. McGibbon's primary focus, of course, is on local policy issues, not on national policy issues. I'm sure that together we can deal with your questions. But if you go to Mr. McGibbon first, and if he's not comfortable, then I can intervene. It's better that advocates don't speak too much during hearings. I think that's the policy, really.
Well, heaven forfend. So that's fine then. Before I start, there's one other thing. We had indicated yesterday that we would move the conditions session to the Friday morning, the morning of the 4th. Now, my wife's got a medical appointment on the morning, and I have two children who will be home. Homeschooling, sorry, they'll be in school holidays that day. So actually, what I'd rather do is, if people are content, is just leave the morning free and we can do the conditions session as originally planned on the Friday afternoon. If that suits everyone, is that? You can let me know if that causes a problem now. But hopefully that's all okay. I'm sorry, Alison, did you have your hand up?
Just that you said the 4th. Just to clarify, it's Friday the 5th.
Yeah, I'm sorry, Friday the 5th. Okay, is it okay if I move on to the agenda, or is there anything else anyone wants to raise at this point? Okay, so if I move on then.
Item 1 is a summary, really, that precedes the item referred to in 1.3, the UK Energy White Paper. But if that's not what you want to do, fine.
No, that's fair enough. I think yes, the 1.1, that document is the kind of 2-page press release, isn't it? The press age, the white paper. So and actually 1.2, which is the 6th carbon budget. They all probably run together at these points. So if we end up discussing 1.1, 2, and 3 together just now, then that's fine. I was going to say that 1.1 and 1.2 were very similar. I think 1.3 was simply there because I think Mr. Kelly had said he wanted the chance to address that. But that's fine. If we end up taking all these points together in respect of UK energy policy, then let's do that. So if I can just characterise it, then I suppose what was said in some of the statements was that wind energy, to paraphrase, if you like, wasn't going to get support in the future, wasn't part of UK energy policy going forward, or wasn't a big part of it. And I just wanted to give Ms. Sidgwick the chance to respond to that, with the usual caveat that there's no need to say again what's already been put in writing. But Alison Sidgwick, did you want to say anything further in response to what you saw in the hearing statements?
Yes, so I was going to deal with this matter and probably deal with the context of the recent white paper as well, because it does make sense to deal with it in one fell swoop. I just pause to observe that the 10-point plan is largely about where government funding is to go. It's not an energy policy. It's a component part of where money will be allocated to be spent. And I think before going on to consider the white paper, it is perhaps relevant to give some consideration to the context of onshore wind as the UK energy position in relation to it has altered over the last 5 years. Prior to 2015, onshore wind received market support through the renewable obligation and the renewable obligation certificates. In 2015, the then UK government was elected on a manifesto commitment to withdraw all market support for onshore wind. And essentially, shortly having taken power, legislation was brought in to essentially revoke the previous support regime which had been in place, and effectively it ceased to exist after May 2016, and there were cut-off dates when applications had to either have consent, get consent, and then be constructed. And essentially there was a small tailpiece in terms of when schemes could come forward. So it wasn't an immediate cession of onshore wind. It was a tapered removal. Now, in terms of that particular decision, you can see the Scottish Government's response to it in the onshore wind policy statement at CD 8.10. And I don't want to go into a great deal of details because we're coming on to Scottish policy. But in essence, the Scottish Government reacted to that change in UK government policy by publishing the onshore wind policy statement and identifying the clear challenges that the very specific sector had given the change that had occurred at the UK level. And indeed, Chapter 1 of that whole document is dealing with the route to market and the challenges that onshore wind would have going forward, given the change in the regulatory regime which had existed to date. So effectively at that point, there is no market support for onshore wind, and there is continuing under a new regime or a different regime support for offshore wind through auction rounds and quite a lot of reference to CFDs, and effectively that's the contractual arrangement whereby offshore wind farm operators bid into a system which is essentially a market-based one, and effectively it's an auction downwards where you bid the lowest and you get taken, and of course within that there's a maximum cap on the amount of essentially support that's up for bidding, and effectively that's a different way of organising a renewables market. But what it does do is it provides that same important driver, which is giving you a long-term base price to allow new entrants and investment in a particular sector. And indeed, you will see from the white paper how successful the CFD auction regime has been at driving down prices in the offshore sector to the extent which they are becoming very price competitive with almost all other technologies, having started off requiring major government support. So the next sort of test was in 2019, and of course by that stage the 2015 government had changed, and there was a different government in place. In 2019, the third auction round in relation to that CFD process for offshore wind also included some elements of onshore wind from remote islands. And that was essentially defined by the minimum level of a length of subsea cable that was required to connect the particular locations. And effectively what Scotland had been lobbying for was the fact that onshore wind had a potential role to play, particularly in relation to remoter offshore islands, where it would be able to provide critical support and generating electricity in those locations in grid circumstances where it would be beneficial. So effectively it was asked for by the Scottish government and was supported ultimately by the UK government, and it was put into the pot, and a number of those schemes, onshore schemes, were successful in that auction round in terms of the UK auction round. Certainly, sir.
Thank you, Mr. Innes. Sorry to cut you off. I just saw that Helen McDade had her hand up. Is it just a detail point, Ms. McDade, that you wanted to make, or is it a point we can return to once Mr. Innes has finished speaking?
I wondered if Mr. Innes could help us by giving us the reference in the hearing statements or to what he's just said, because seemed wider than the point that we're discussing. I just wondered if he could help me with the reference to where that is in Alison Sidgwick's statements, rather than a wider discussion.
Sir, if I may, the applicant didn't put a representation that onshore wind was not getting favoured or any UK government support, and that it was likely to be phased out. I'm responding to that and setting the context for where we ultimately get to, which is the white paper, which I'm about to come to. But it does, I think, in my submission, it is only fair that that has a proper context before we get to the position where I say that assertion that onshore wind is not supported is simply wrong. But that's in terms of the history. I've actually got to the stage of 2020 and the white paper, but it understands what the CFD needed to explain, because obviously we're about to come to that. But it's not the first time onshore wind has been potentially within an auction round, and I think that is important context. So that's exactly what I'm going to do, and I'll now move to the white paper, if I may. And that's CD 8.31. And I think it is important to recognise that this white paper represents a significant change in UK government policy. There have been a number of policy announcements that have been made by the current UK government since coming to power, and these are all wrapped up in this white paper. But this provides the full context of the ambition that the UK government has in relation to energy, and it represents, in my submission, a seismic shift in the policy. And I think it's important to understand that at the outset, the government at page 4 recognised that we're on the cusp of a global green industrial revolution, is how they put it. And they then relate that to the compelling case for tackling climate change. And I think that's obviously the context. And the question is, they then consider what the consequences for the UK are if global effects on warming do occur, and the consequences for the UK. It also then tries to give some projection forward about where the UK is emitting and setting out which aspects of our lives, whether it's buildings, business, industry, or power, that is contributing to climate change. It then goes on at page 9, not to set a specific ambition in relation to how we get to the climate change targets, but an illustration of how we get to it. And I think what's very important in an energy sense is on page 9 of the document at figure 1.4, there is a diagram illustrating at 219 the various energy uses, and then it illustrates a net zero scenario promoted by the Climate Change Commission. Now, in terms of what that is telling us, is that transformation is predominantly occurring by, first of all, the reduction of energy use and a massive expansion of electricity. And I think that's a key part of that. And at the top of page 9, it talks about a 500% increase in the amount of renewable capacity connected to the grid from 2009 to 2020. And it talks about that ambition going forward. And that's really a very important part of the context. Now, I think it's important when setting out these policy objectives to have regard to essentially the principles that they're working to. And I think if you go back to page 4, there's 3 key principles that are set out in terms of the energy policy. It transforms energy. Now, again, I think using the word transforms is the scale of the change, supports the green recovery, and creates a fair deal for consumers. And again, if you read through the white paper, it is a key component part to make sure that the transformation is undertaken in a way which does not impact on consumers and is very cognizant of the effects of potential rises in energy prices. But insofar as today's proceedings are concerned, the key chapter is chapter 2, which is related to power. And at chapter 2, on page 38 of the document, we see the goal. And the stated goal of the UK government is electricity is a key enabler for the transition away from the fossil fuels and decarbonising the economy cost effectively by 2050. And I think that, again, is a key objective, and again recognises the particular role which electricity is going to play and have to play in our drive towards net zero. In terms of the document, it then goes on to essentially at page 45, in terms of affordable clean energy, electricity, it sets out our key commitments. And in terms of that, we see one objective is to target 40 gigawatts of offshore wind by 2030, including 1 gigawatt of floating offshore wind, alongside the expansion of other low-cost renewable technologies. And that's the heading under the renewables section. It then goes on to describe that there was a highly competitive contract for difference CFD allocation round in 2019, led to the procurement of 5.5 gigawatts of offshore wind. And this is the reference that I say to 275 megawatts of remote island wind. So that was the context on page 45, the first column, to the statement that I made about the 219 auction. And we see there the discussion about prices coming down. And what they say is, as announced, they're going to hold regular auctions, and and every 2 years to bring forward a range of low-cost renewable technologies. So again, using that word, a range of low-cost renewable technologies are the future. And it then goes on to say the next auction in late 2021 will be open to onshore wind, solar, and other established technologies, as well as offshore wind. Then an important part is subject to sufficient projects coming forward through the planning pipeline to maintain competitive tension. The aim of the government is to double the capacity awarded in the last round and to deploy 12 gigawatts of low-cost renewable energy. It then goes on to make the following statement. Onshore wind and solar will be key building blocks of the future generation mix, along with offshore wind. Now, I don't think you can get a clearer statement of the UK government energy policy in relation to these matters. And in my submission, there is absolutely no ambiguity about the role which onshore wind has in relation to UK energy policy. And if I may say, I suspect that a lot of this has been that the UK government have listened to both the Scottish government and the Welsh government, both of whom have positive frameworks for the deployment of onshore wind, and therefore they recognise the importance of these particular technologies to these parts of the United Kingdom. And finally, in relation to matters, I don't want to take up much detail on this, but insofar as grid, and we might be coming on to look at grid matters this afternoon, there's a whole section in the white paper called the Energy System, Chapter 3, and it recognises that in order to achieve the ambition to net zero, we're going to have a fundamental rethink of how our grid operates, and in particular, what's required to facilitate the very different formats of generation and where they're all going to be located. And that is building upon work that's already been undertaken and is being undertaken by Ofgem and others in looking at future network infrastructure and how that can be worked in terms of low carbon. And I think the key issue here in many respects is this, is that the demand profile is clearly changing in terms of electricity, in terms of the future need for electricity. Based on the white paper, it's going to grow, and therefore grids need to match that ambition to be able to fulfill many of the technology advances that we're seeing as part of this climate change revolution, and the opportunities that affords in terms of the changing the ways which we live, operate, and transport, and etc. So, as I say, in my submission, the white paper is very clear. I don't think in any way you could possibly articulate that it downgrades onshore wind. And in my submission, on the clear terms of the policy, it's the strongest position that onshore wind in the UK has had for some time, and there is absolutely no ambiguity in relation to the matter. And that really concludes the applicant's response, sir.
Okay, thank you, Mr. Innes. That was a comprehensive response to my question. And I think that covers the whole, 1.1, 1.2, and 1.3. We needn't artificially separate these out. And taking that as your response in terms of government energy policy as a whole, we will come on to issues about the grid later, because I put that later on the agenda. But very shortly, you're taking from the white paper that wind is part of the future, if you like, or will be part of the future, onshore wind. I just want to give the other parties the chance to give me their take on all of this. as I say, I think if we just, I think if I take it, I can hear from each of us, each of you individually, and then we can maybe move on to Scottish policy. So if you just think of 1.1, 1.2 and 1.3 in the agenda together, Ms. McDade, do you want to say anything in response to that, or give me your take on it, if you like?
I do. I see Mr. Campbell has his hand up. I don't mind if he goes first, if that's your usual order, but whichever.
I don't have I'm not too troubled. I think I was going to go to you first because you've probably given me most evidence about it. But Mr. Campbell, have you got sorry, Mr. Campbell, have you got a question or want to come in?
Mute. Mute.
I have 3 short points to make, but I'm quite happy to go after Helen if that's what you wish. Please.
Okay, thanks. I've got a few points, and I don't disagree with anything that Mr. Innes read out from the energy statement. I do, however, disagree about where it leads. So his point about onshore wind will be part of the mix going forward, and I don't think anybody here is suggesting that there will be no more onshore wind built in the UK or Scotland. So that is not really the issue. I did think that the references to the contracts for difference for offshore and the ones that have already been made are quite interesting because, of course, this links into a question later on, several of those have not started to be built because presumably at the moment they are not finding that economic at the prices that they bid for. So the fact that something gets a contract for difference doesn't mean that it necessarily goes ahead, and certainly that has not been shown to be the case from the ones offshore for various reasons, some of them grid related. So I don't want to label. Nobody disagrees that electricity will be a key part of going forward. What I think, just want Sidgwick's hearing statement theme throughout hearing statement 4.3.4, and Mr. Innes has just also. I think, well, certainly I am not here discussing trying to with this particular place. That's the leap that.
Sorry, Ms. McDade, can I just step in just a second? I don't know if you can hear me, but I certainly lost what you were saying there, and I've lost your video. Are you still there?
Okay, my video seemed to switch itself off. I don't think I pressed anything. Well, whether they're also dropping. So apologies for that.
No, it's okay. I wonder though whether maybe while you're speaking, could you maybe turn your video off anyway, because it might be just.
I'm not hearing you
now.
With
bandwidth. Right. Can you hear me now?
Will I carry on?
Can you hear me, Ms. McDade? I wonder. I'm just going to ask.
I'll switch my.
Okay, thank you. So where you dropped off for me is when you started to refer to Alison Sidgwick's hearing statement at 4.3.4, but it was intermittent after that. So could you maybe just jump back to that point? Yeah,
it's a point that comes up in many times, so I don't need to quote that exact point, which you've got the number for that one, where the reference to the drive for increased renewables and clean electricity is then, in my view, conflated in the statements with the need for onshore wind and in this particular place. And my argument is that I disagree with Mr. Innes that the UK government energy statement suggests a large increase in onshore wind. it clearly states targets for offshore wind, which seem to me to, can you hear me?
Yeah.
Yes.
Yes.
Seem to me to clearly show that they're looking particularly at offshore wind, but of course other clean electricity is nuclear, which they mention, solar, which they mention. And so again, Ms. Sidgwick's statement comments on the fourfold increase in electricity. And the government has mentioned a 40 gigawatt target for offshore wind. And at the moment, that is about 11 gigawatts. So it does seem to me that there's a clear connection there, that most of that target is looking at offshore wind. But I do disagree that the fact that they are now included for contracts for difference means that these sites would definitely go ahead. And I would point to the ones that already have not, and also to the fact that there's not much of a penalty if someone who wins a contracts for difference does not go ahead. So it's more an options than a definite statement. I did also want to say on the 6 carbon budget, if we're putting that in here, my main point there would be that the Committee on Climate Change is not a government agency. It is an independent advisor which suggests different ways of achieving the targets which are there to be achieved. And again, Ms. Sidgwick's hearing statement of 4.3.2 and 4.3.3 refer to those targets. And again, they're talking about greenhouse gas emissions targets. And no one, again, is disputing that. Certainly I'm not. And it does mention, for instance, in one of those 4 key ways to achieve that, land and greenhouse gas removals, which I think is a peculiar way of saying keeping the greenhouse gases in the land or making sure it's taken up. And of course, peatlands are one of Scotland's major contributions there. And peatland restoration is mentioned, but peatland protection in this case is a key factor for this. So I think, again, the 6 carbon budget does actually support protecting this site. Thank you. I think that's my main points.
Okay, thank you very much. I'm sorry for the connectivity issues there, but I think I heard you fine. We'll come on to there was an issue about, there was one of the later items was discussion about grid and yeah, I'd made a note, and I wanted to come back and ask you about that point about the difference between getting a consent and or an actually implementation of a scheme. I'm hearing a bit of rustling of stuff. Mr. Campbell, if you turn your microphone off, I don't know, I'm not sure you're the only offender, but yeah, that's great, thank you. Okay, and sorry, Mr. Campbell, having asked you to turn your microphone off, I'm now going to have to turn it back on again and tell me what you're going to tell me. Sorry.
Thank you very much. I think there are 3 things that I'd like you to note. First of all, Mr. Innes has quite naturally taken you to the part of the white paper which is important for onshore wind. It is entirely unspecific as to location, as you would expect. Secondly, it's a white paper, and that is, if I understand the process correctly, a paper which signals government intentions subject to legislation. I'm sorry if I state the obvious. The signaling of intention is underlined in the document several times by the use of the expression "when parliamentary time permits." So what we are looking at here is not an enactment, but a signal of intentions. And Mr. Innes is quite right to draw our attention to it. However, it is quite a big jump from a signal about the whole transmission system, including the grid, to looking at the specific requirements for a particular project. So Sorry, my phone's ringing. Let me just switch it off. The only passage in the white paper which deals with onshore wind with any degree of precision is on page 45, which tells us what we know already, which is that the next CFD round in 2021 will be open to onshore wind. And that's not new, because there are already onshore wind projects which hold CFDs and indeed are progressing towards construction, or indeed have been constructed. Whilst I agree with Mr. Innes's submissions, although he sounded more like a speech, but submissions in relation to onshore wind being a key building block, which is what it says on page 45, that is the only specific reference to the deployment of that technology. The last thing I'd like to say is that, unfortunately for you and Ms. Kirkwood, you'll have to read the whole document because it's very wide-ranging. And it won't take you that long, but it isn't a document directed towards only the type of technology we're looking at in this examination. I hope that's some help. Thank you.
Okay, yes, thank you, Mr. Campbell. Yeah, yes, I have read, not the whole thing, but I've certainly read passages of the white paper. Mr. Kelly, your obviously some of your evidence touches on these things, and of course you'd said relevant to item 1.3 that you may want to take the chance to respond to the white paper itself. Have you anything to add to what we've heard so far?
Thank you, sir. No, I don't need to add anything to what Mr. McDade and Mr. Campbell have said. They've covered the points I would want to make, so I don't need to take up any more time with that. Thank you.
Okay, thank you. I mean, I don't want to spend much more time necessarily on UK energy policy, but Mr. Andrews, do you have anything to say on it? I'll come on to you, Mr. Buckoch, as well. Certainly, I'll give you the chance. But Mr. Andrews, are you there? Yeah.
Yes, hello, good morning. I don't have anything extra to add on policy, the white paper at the moment. Thank you. Hello, can you hear me?
Yes, I heard that, Mr. Andrews. Thank you.
Okay.
Well, you said nothing on the way on UK energy policy, but I appreciate you may have other contributions as we move through the agenda. Mr. Buckoch, you had your hand up there.
Yes, can you all hear me? I just really wanted to refer a question or two to Helen McDade, if I may. But the background to that is that it seems very clear to me from the 10-point plan and also from the CCT material that offshore wind is prioritised. There seems no doubt about that whatsoever. And I just wanted to ask Helen McDade a couple of questions which relate to the reasons, some reasons why that is, which I don't really see as being sort of political reasons at the moment. So could I just, because Helen McDade did refer to balancing mechanisms, I believe, in her response. Was that correct? And first of all, I would ask whether she would agree that the current situation the question of balance is, clearly achieved between obviously when you get intermittent renewable failure, there's capacity in the system to completely meet the peak demand. And I would, first of all, would like Helen McDade to confirm that impression one gets is correct. That there is a sort of a principle at work which applies to the operation of the grid. Would she agree that that is the case? Yes.
Yeah, and I think there is a point about this. Yeah.
Yeah, I mean, I just
I think this comes up under but want to discuss that.
I'm listening, but it just seems to be, these questions seem to be relevant to, immediately to, the policy stuff that we're considering at the moment. And I just wanted to raise these points with you. I mean, to cut it, a long story short, the future models or the scenarios which are covered, particularly by the CCC and also by the Jacobs report, which represents national grid material as well. These future scenarios don't, to me, appear to balance the system in the way that the system is balanced now, and nor does there seem to be any attempt to balance that. And what I'm suggesting is that the uncertainties, Mr. Reporter, may I just finish what I was going to say, and then the uncertainties surrounding these 2050 scenarios seem to be an important reason why governments are looking to achieve greater security. And of course, the capacity factor argument with respect to offshore wind is a critical one in that respect. And that's, really what I wanted to say on this. And it kind of directly reflects the current position and, this shortfall in these future scenarios, which does not appear to be met. And, that being a motivation for promoting, amongst other things, amongst other measures, promoting offshore wind. I think that's pretty well. I mean, there's further detail I could add, but I think that pretty well sums up what I wanted to say here.
Yeah, if I can just address that very briefly, Mr. Little. I mean, yes, certainly there's a major issue there about balancing the grid, and as you say, the offshore wind with a better capacity is certainly an important factor, and also the factor of it being more widespread shows that wind doesn't necessarily all drop at the same time. So I mean, these are major issues which are coming up, and I think that's why I wanted to discuss the black start remark in Ms. Sidgwick's report later on, because I think that is related to growing concern amongst industry and government about balancing the grid. So I mean, I think that's certainly my view. Is you're correct on that.
Thank you.
You're still muted, sir.
I beg your pardon. So that's fine. I think I've given everyone the chance to address us on that first part of the agenda on UK policy. We're going to come back, as Ms. McDade mentioned there, for example, black start, but other things we're going to come back to later. Are people content that we can move on to item 2 on the agenda, which is Scottish energy policy matters? You can just wave your hand or shout out if you're not in agreement. Okay, okay, that's fine. Thank you. Under item 2 then, which takes us into the Scottish energy policy context. Now, the first one, 2.1, Mr. Kelly had referred to the climate change plan and at paragraph 24, and we'd wondered what that document was, but it just looking again at the documentation, Mr. Kelly, I wondered whether it was what you had been referring to was CD 8.13, which is the third report on the policies and proposals. Is that the one that you've been referring to there?
Thank you, sir. No, we can actually update matters because you now have the Scottish Government's climate change update from December, climate change plan update from December of last year, and I'm content that you focus your reading on that. There's no need to go back to any historic documents. We can now look at the December document.
Thank you. You anticipated my follow-up. So that's CD 8.32, which we're going to talk about at 2.4. Is that right? Okay, fine. Thank you. Just bear with me a moment. Okay, if I can just move on then to 2.2, which relates to the Climate Change Act, and hopefully this is just a short kind of clarification point. The applicant's position statement refers to section 44 of that Act, which imposes certain duties on public bodies, and I don't think I've come across it before, so I just wanted to know whether people think that those apply to ministers when they're going to come to determine this application. Mr. Ennis, have you got a view on that point, first of all?
I think the key point about this is that this is the teeth of the targets, and when the Scottish Government talks about effectively having some of the toughest targets in the world and them being lawful, this is the lawful bit that creates them being legally binding, in the sense of when exercising functions, public bodies must do so in a way best calculated to contribute to the delivery of the targets, or best calculated to help deliver any programme laid before the Scottish Parliament under section 53. And as I understand it, that climate change plan, the previous one, had gone before the Scottish Parliament had been passed and was laid before it, and it then has a status. I think it is likely that the current document will have been submitted to Parliament, but I'm not quite sure at this stage whether it has the status of having been approved or whether it's a negative resolution, but I'll double check that. But that's that in subparagraph B would be a programme essentially delivered to the Parliament for essentially delivering the climate change. So insofar as those two aspects are concerned, I think in considering this application, the way in which government can operate is that clearly by exercising functions, it can formulate policies and it can formulate actions as well. So in terms of this is, in my submission, a fairly all-pervasive statutory policy requirement, in the sense that these are designed to be at the heart of all decision-making and in terms of formulating policy. What it also does, though, is in terms of the targets, it's got the objective of achieving the targets and also delivering the programme, but there is a proviso that it also must be in a way that it considers most sustainable. So in terms of that, you'd have to consider the complete package of issues whilst it talks about meeting those targets and supporting the delivery of the climate change plan, it also has to be done in a way that is sustainable. And Section 92 defines sustainable development, which is in traditional terms. So I think it's, to be fair to it, it is actually not just a blanket thing of you have to achieve these two objectives. You have to do it in a sustainable way as well. So that's how I read it. And insofar of its discharge, I suspect that in respect of many functions, how it will be discharged is through the formulation of a policy. And that is how you would perhaps deal with some of the wider aspects of how you implement these requirements. But equally, in my submission, determining a Section 36 application is exercising a function. The Scottish ministers are exercising a function and are therefore caught. But as I say, it comes down to the targets, the plan, but also sustainable development. And I think being fair in terms of this overall policy piece, there is always an element of no one factor completely overrides any other. And ultimately, there is a balance as to how that's achieved. But I think it significantly increases the importance of the climate change targets and also the delivery and implementation of the climate change plan as considerations. But it doesn't rule you to one outcome. And I certainly wouldn't suggest it would do so. It is part of the decision-making process, and all the factors would have to be taken into account in an Electricity Act case. Those that strongly support, those that oppose, and the impacts. And so, but as I say, I think the primary purpose of referencing it is the importance of these new targets, which I think is fully set out in Alison Sidgwick's paper, which are both on the interim basis to 2030, and that upping the 2030 target and bringing it forward, it is essentially an intensification of requirement. And the other aspect is to measure the progress there. Effectively, the Scottish Government set annual targets for them to achieve as well, and that clearly demonstrates, I think, a real need in terms of Scottish Government policy in making sure we hit that 2030 target because of its importance. It's not just left to that timescale.
I mean, I think we do have. You moved on there to a wider point about targets and what the policy emphasis is, which I think we've got on the agenda for later. Now, ministers have, can take their own legal advice on that, and I'm not asking for legal advice from people here, but my point was a narrow one, much narrower one than you addressed there. That section of the Act relates, it refers to public bodies, and my simple question was, does that mean ministers in this case? Does it have legislative effect for ministers in making this decision? Yes. You think it does. Mr. Campbell, do you have a view on that?
No, probably for the first time so far in this case, I agree with Mr. Innocent. It clearly embraces decisions made by Scottish ministers to work towards the climate change target, subject to the dictates of sustainability, about which we have something to say later on. I don't see how that can be argued any other way.
Okay, thank you. And Mr. Ennis said he's not saying that means this is a shoe-in. You still have to make that balancing exercise. It's just that, yeah. All I want to get a view on was whether
if it was a shoe-in, we wouldn't need to be having inquiries like this. Scottish Power would simply identify some land and put up the turbines. There are clearly there is a balancing exercise within the body of the text of the Climate Change Act, and Scottish ministers are not immune from applying that. Neither is South Ayrshire Council, come to that, because it's a public body as well. So, with respect, I don't see that this is a matter for debate necessarily.
No, I'm quite content that it isn't. If everyone else is happy to move on, I just wanted to establish that narrow point really. Okay.
Can I
just raise one point there? The Climate Change Committee, have made quite clear that the kind of exploration of the future are a work in progress, and the Scottish Government white paper also states that this is, you've got to remember this is a work in progress. I see a conflict between that idea and this insistence on sort of targets that must be met. When in actual fact, also the Climate Change Committee has warned the Scottish Government to not go too fast here, to make sure they make the right decisions and take a measured response to this. So that would be my criticism of the way that this debate has been cast right now. That's what I've got to say there.
Okay, thank you. I'm sorry, Ms. McDade, were you going to say something as well?
Yeah, just because Mr. Innes raised a couple of points there. Like Mr. Campbell, I'm pleased to agree with him. I'm no expert on the legal points, but it seems obvious that this does apply. My point relates to the section being discussed in that in Alison Sidgwick's statement, the point she made after that was this requirement is in contrast to other legislation. So I am confused by that because sustainability comes up throughout everything. And in relation to what Mr. Innes just said, and I'm just highlighting that question really, I didn't understand her point. It seems unexceptionable to say that this will be done in a way that considers most sustainable. I would just point out that the primary target is greenhouse gas emissions. Renewables are a secondary target to achieve the greenhouse gas emissions reduction. That is what this is all about. And within that, again, I would point out that peat is a key point. Scotland has one of the best peat resources in the European continent, and we need to protect it as well as restore it. And the Scottish Government recognises that. So that would be something that falls within that specific clause in there, as well as obviously elsewhere in natural environment. Thank you.
Okay, thank you. Sorry, I'm just noting that down if you give me a moment. Okay, can we move on to 2.3? I'm just looking up, nobody's saying we can't. I'm conscious, I said we would have a break. I'll maybe see if we can do 2.3 and 2.4 and then have a short break, because then that's a kind of more natural one. Let's see how we get on. So 2.3, yeah, in fact, we perhaps may not need to discuss this. We don't have any, I think we understand what people are telling us or what they're taking from the onshore wind policy statement, which is CD 8.10. So I don't necessarily have any further questions in that. The purpose of 2.3 was to give Mr. Kelly the chance to expand on what he'd said about the Arecleoch decision. But I think from what I noted yesterday, from your earlier email, you said you were happy, Mr. Kelly, just to leave out discussion of Arecleoch and just move on. So subject to what you say, Mr. Kelly, then is 2.3, do we need to discuss that at all?
Just one point. The discussion at Arecleoch came up in the context of assertions by some parties that Scottish planning policy and NPF 3 were now out of date. I don't know if we'll pick it up later in the agenda, but the NPF 4 position statement at page 6 confirms that ministers have made no decision on future planning policy, and that the current states specifically the current NPF 3 and SPP remain in place until NPF 4 is adopted by ministers. So I'm perfectly content just to leave it on that basis, sir. Thank you.
Okay, thank you very much. And yeah, and we'll come on to that kind of policy, context later on. Anyway, okay. So the last question, or the last item rather, on Scottish energy policy was, it's again one for you, Mr. Kelly, in the first instance, I think. So it's 2.4. I think you'd said in your hearing statement that you might want to comment on the climate change plan update. In fact, we talked about it briefly earlier this morning. The Securing a Green Recovery on a Path to Net Zero Climate Change Plan 2018 to 2032 CCP update. We don't have any particular questions on it, Mr. Kelly, but you said you might want to talk about it, so I just want to give you that opportunity.
Thank you, sir. Again, if you haven't read it already, it's a hefty bit of reading for you that seems to cover an amazing number of subjects, and makes various assertions as to what might happen in the long-term future. Only 2 points I want to refer you to. Page 11 relates to the targets or the intended targets for offshore wind in terms of the Scottish Government. But importantly, it also says that the Scottish Government intend to produce an energy strategy update in 2021. So we don't know what that will contain, but that we can anticipate that that will set out the future thinking on energy strategy, and probably that NPF 4 will tie into that. But other than suggesting that you read the whole document, we haven't done so already, I have nothing further to add to it at this stage. Thank you, sir.
Okay, thank you. Are there any other points to be made on Scottish energy policy, or this, if not, my suggestion would be this is a good time to take a short break before we come on to the next item on the agenda. Is everyone okay with that, Mr. Campbell?
I had a question about Ms. Sidgwick's inquiry report, which I'd like to put to her through you. It might take me a few minutes. You might want to do it after the break, but just so that she can look at it, it's paragraph 4.4.5.
Okay.
I can ask it now or after the break, whichever you prefer.
Well, maybe we can have the break now, and that will give Ms. Sidgwick the chance to turn that out and have a look at it. So, can we come back? It's 11:09 on my screen, so we take him back and ready to start at 11:20. So if everyone just turns their mic and their video off, and we'll come back at 11:20. Thank you. Okay. Hopefully we're all back and I've had a chance to, well, in my case, get a cup of tea or whatever it was you needed to do. Mr. Well, Ms. Sidgwick, are you with us, or is it Mr. Innes? Hi, good morning. Okay, Mr. Campbell, you were, I believe you had a question from Ms. Sidgwick in relation to her hearing statement, so I'll just pass over to you.
Thank you very much. Ms. Sidgwick, if I could take you please to your hearing statement at paragraph 4.4.5. You say there, I'm reading it short in the last sentence, page 47 of the document, which is the Programme for Government document, is clear that the refreshed energy strategy will collate all the actions into a coherent strategy with the aim of transmission to net zero. And what I wanted to ask you was, a coherent strategy for what?
My reading of that is that, as Mr. Kelly said earlier, that there's going to be a refreshed energy statement that will come out, and that energy statement will deal with a number of issues and things, and that will look at the role of renewables in replacing fossil fuel as part of fuel heating. It will look at how we aim to get to net zero and things like that, and it will pull it all together, all the different elements that need to be addressed to get to the various targets and things. It'll pull it all together in a coherent strategy.
I see. Well, that's clear enough. Thank you. Do you know whether a strategy of that kind will require a strategic environmental statement as part of the process?
I'm afraid I don't, and I don't know if the previous one, the existing one from 2017, had one or not.
Thank you, sir. Those are all the questions I had on that paragraph.
Okay, thank you very much. Okay, I'm going to move on then to item 3, which is the electricity, which is about the Electricity Act 1989. It might not be that we have to have much of a discussion about this anyway. It would put there in the agenda that some coverage in some of the inquiry statements or the written evidence about Schedule 9 and what's said in there. Mr. Campbell, can you turn your microphone off, please? I've got a lot of yeah, thank you. There's some coverage in the written submissions about Schedule 9 of the Act. And I suppose what it boils down to is our questions: do the parties, do people think that Schedule 9 contains a development management test? I suspect the consensus is that it doesn't, and maybe if that's the case, we can just move on. But I wonder, Mr. Campbell, from the council's point of view, or indeed Mr. McGibbon, but is there a view on that question?
Yes, sir. The case of William Grant Distillers makes it quite clear that the Section 36 process is a self-contained code, part of which is Schedule 9, and that you read it for what it says. It has two components: the consideration of the desirability of conserving natural beauty and the extent to which the applicant has mitigated potential effects. I'm reading it short. We think it is part of the criteria which a council or a decision maker should apply to any Section 36 application. Because a consent under Section 36 imports a deemed planning permission under Section 57 of the Town and Country Planning Act, it's also relevant, of course, to look at local authority policy as it has been adopted or is emerging. So the two things remain a consideration, but both are development control tools for the decision maker. I hope that's a help. I don't think there's anything new there.
Okay, no, that's fine. That's all understood and as expected. Mr. Kelly, do you have anything to make at this point?
Yeah, I was involved in the William Grant case that Mr. Campbell refers to. The only issue I have is that if you take it as a separate code, and if you take simply the literal wording of the schedule in the Act, as I said to Mr. Steele QC at Darnell, it's almost impossible to fail because the requirement is just to have regard to. So I take a slightly more nuanced approach, as the council have done, and try to import a sort of development acceptability test to it. And I do so because I bear in mind the age of the Act, it's 1989, and the purpose of the Act. The Act was never drawn up to enable the assessment of onshore wind farms. It was about the privatisation of the Electricity Act and the connection of large thermal stations to the grid. So I take a slightly more nuanced approach to it. But obviously, as Mr. Campbell has pointed out, we can't dispute what the actual words say in the schedule. Thank you.
Okay, that's fine. I'm going to give Mr. Innes the chance to comment, but is there any, Mr. Dade or any other of the objectors, do you have any other points to make on this part of the Electricity Act, or can I just move on to give the applicant a chance to respond?
I have nothing to say, thanks very much.
Okay, thank you. Mr. Innes, I'm not sure whether it's you or Mr. Gibbon, but I'll pass it over to you then.
Yes, thank you, sir. In terms of the Electricity Act and Schedule 9, I think it is quite important to get this right, because I think it does cause problems in Section 36 decision making, and there is not a current consistency in the way that it's been dealt with in decision making. And I think that is problematic in the sense of, I think there should be a clear understanding of what the purpose of the provision is and how it's dealt with in decision making. In terms of the approaches, I think CD 920 is a ministerial decision in relation to Section 36 application for Largo Rig, and it was essentially an extension to an existing scheme, and the existing scheme was of a scale that it then required this to be considered as a Section 36 extension. Insofar as the issue of Schedule 9 was concerned, in that particular decision making, the reporter in his recommendations had found effectively that he felt that the applicant had failed in the duties under Schedule 9, and essentially was one of the grounds taken into account in the decision making. At page 8 of the decision letter, the Scottish ministers then consider that particular aspect, and that's the only matter of relevance really in the context of this decision. I'm not finding on any of the facts or anything else. It's merely the fact that it's a decision whereby Schedule 9 is engaged. And effectively, at the top of page 8, the decision that the reporter made was it was all about a balance of, it appears that the existing turbines were in a bowl, the proposed extension was larger, and effectively were in more prominent positions. And the reporter considered that the company should have essentially kept to smaller turbines, kept to the existing design approach, and as a consequence, failed with Schedule 9. The Scottish ministers then report the conclusion reached that there was a failure of the duty. The Scottish ministers then make the statement that the Scottish ministers disagree with the view of the reporter on this matter. Scottish ministers note that Schedule 9 of the Electricity Act contains no substantive development management tests. Ministers consider that the environmental information sufficiently accounts for the consideration of the design of the proposed development and its impacts on the environment. The company has demonstrated throughout the ES that they've had regard to the relevant environmental matters, and within the parameters of their chosen design, taking into account the environment as a whole, they've done what they reasonably could to mitigate any impact. Ministers are therefore satisfied that the relevant requirements have been complied with. Now, what that does is, if you take that interpretation of Schedule 9, effectively what we're looking at is the specific proposal that's been put forward. Has the applicant done what they can in relation to that specific proposal to consider the effects, and thereafter to provide reasonable mitigation? And I think on Mr. Kelly's reading, as he talks about the light sift, that is entirely how the Scottish ministers considered it in that context, and effectively have really viewed it as a process to be gone through. And there is other case law which it might be helpful to refer you to in the closing submissions. And I'm sure Mr. Campbell will be quite familiar with the cases, but that's the Trump Organisation against the Scottish ministers. And whilst it dealt with a slightly different issue in relation to Schedule 9, what was interesting in the in-house of the Court of Session is one of the judges went through the full history, I think it was Lord Malcolm, of the background to Schedule 9, and ultimately made some obiter comments also about its application, insofar as you were surprised, I think, almost to the weight that was being given to it, because if you look at environmental impact assessment regulations, the topics covered are greater. The requirements on the decision maker are now even greater since 2017, in the sense of having to reach reasoned conclusions on all the impacts, and thereafter also having to give consideration to the mitigation, cumulative impacts, so a whole range of factors which will be broader than effectively the Schedule 9 duties, which, according to Lord Malcolm, were really a throwback to what had previously been imposed by electricity boards. And if that's correct, then really I would submit that you treat Schedule 9 as a distinct part of the decision making. You have to look at the material that the applicant has put forward and say, have they had regard to these matters? And in my submission, the environmental statement fully sets out those matters. And equally, within the environmental statement, great care has been given and consideration given to mitigation of effects. And in my submission, it shouldn't be that hard to reach the conclusion that we've met the Schedule 9 tests in terms of the schedule. I would then, in my submission, treat the decision-making and the recommendations in the actual proposal is, in my submission, the classic balance between those factors that support it, energy policy, aspects of local plan, and those that are negative. And I think keeping the two separate seems to me to be quite the best way to reach a proper view on it, and not mix between the broader decision-making as to whether the project should be consented, having regard to all those policy and other matters, and the Schedule 9. And I think whether some of the difficulties have come is where that Schedule 9 steps gets introduced into decision-making, because in fact, applying Schedule 9 is far too narrow. It doesn't consider all the environmental impacts. And equally, if one's taking a pretty tight view in it, it might actually only be the protection, physical protection of cultural heritage assets, as opposed to the setting. So in my submission, it was of its time. It is limited. The environmental statement demonstrates how the applicant, in respect of this proposal, has very carefully considered the effects and the mitigation. But in my submission, it's best. I agree with the reasoning set out in CD 920 on page 8, and I think it keeps things clear, and there isn't the confusion of trying to work out, in terms of the ultimate decision whether to grant or refuse. Schedule 9 is a distinct self-contained code that needs to be dealt with. But in my submission, given the advancements of environmental assessment, it is very likely that where a proper and adequate environmental assessment and report have been submitted, that the applicant will have fulfilled their duties under Schedule 9.
Okay, thank you. Yeah, it does seem, as we gleaned from the written submissions. Sorry, Mr. Campbell, on you go.
Well, on this analysis, which Mr. Innes has just treated us to, Schedule 9 has no purpose. And with respect to him, that can't be right. But what was said in the Falago decision is that it contains no substantive development management tests. Now, that's true. It doesn't contain tests such as you would find it in a local plan. It doesn't contain other than the broadest possible criteria. But it is not an empty shell, because it is part of the code under which this application is made. And Mr. Innes and his team have to recognize that, which I think they do. And Ms. Sidgwick's statement is completely clear as to her view of how Schedule 9 is applied, and so is the accompanying material. But it's not an empty shell. It doesn't mean nothing, if I can put it that way, rather strangely. It's not a pointless piece of superfluous legislation, which is what I think we're hearing from Mr. Innes.
Okay, I mean, I think I understand people's positions without needing to dwell any more on this point if people are content. Can I move on then to item 4, which is the Scottish Renewable Energy Targets? And if I just go over what we said in the agenda. The applicant states in its position statement that many of the onshore wind farm schemes which are awaiting construction are historic and they're no longer viable as currently consented. Also, that some of the onshore wind farm schemes which are in planning are no longer viable and will never be built. Sorry, one of those should be offshore, I think. So that's fine as a generality, but we just wondered, is there hard evidence for that's actually quantify that? And I suppose the kind of flip side as well, if some of the schemes should be treated as not viable and are not going to progress, then how do we know this one's any different? Does the applicant want to respond on those points?
Thank you. There's a few things here. There's not any hard evidence for the number of schemes that are not being progressed insofar as I'm aware. But what I and others who are working in the industry are aware of is that there are a number of these schemes that haven't come forward for a variety of reasons. And it means that there are some schemes that are sitting in a sort of consented capacity that are unlikely to ever be built. And therefore, when thinking about where we are in respect of targets, regard has to be had to that. There are a variety of reasons why schemes aren't built. There are a number of fairly historic schemes that are sitting in the system that were taken forward on the assumption that they would get the renewables contracts, the ROCs finance. That didn't happen for a number of reasons, and so that those schemes which are of an age and are largely small-scale turbines are not considered to be financially viable. There are other schemes where there may be situations where there are radar constraints and things like that come in. So there's a variety of reasons for that. And the onshore wind policy statement in the route to market notes the sort of the financial constraints that would apply to some of those. Scottish Power have brought forward a number of sites, including Helsry and Benanturk 3, with no rocks. They've moved forward with a number of sites since the 2017 document and the sort of support from Scottish Government that came following on from the Conservative government's removal of the financial support for onshore wind, and those sites are being moved forward in the current climate. They've built sites, and Scottish Power are one of the companies who have done that. There aren't a huge number of companies who have done it. Gordon Bush Extension is one. I think Kyleaky is another one that has come forward. Scottish Power aren't really in the business of gaining consents for sites and then not bringing them forward. They tend to gain consent and then to build and operate the sites that they're bringing forward. I'm assuming we'll come on to sort of some of the other constraints that may apply to sites later on in the context of some of the other agenda issues, so I haven't covered them here.
Okay, thank you. Yes, Ms. Sedgwick, will some of these things are picked up in some of the other agenda items, so we'll hope we come on to it. Mr. McGibbon or Mr. Campbell, I'm going to come back to the other objectives, but does the council have anything to add on this point?
No, we don't. The point will be made in closing submissions that South Ayrshire has, and indeed it's made by Mr. McGibbon, that South Ayrshire has respected the Scottish Government's drive for increased renewable capacity by locating proposals on high plateau ground. And you can see those surrounding the Arecleoch wind farm, or the Arecleoch wind farm itself, and the neighbouring wind farm. That's been its position all along, but it's not concerned with overall Scottish targets, and I wouldn't want to give evidence myself on that matter.
Okay, thank you. Ms. McDade, you made the point, and I think I'm going to ask you about it later. I can't remember which. I think it's later on under 4 anyway, about the fact that the implications of having lots of schemes consented but not developed. But I suppose just is there anything to add on this shorter point about the reasons for why those schemes aren't progressing?
As you said, I'm happy to discuss that now if you want, because I points that are related to that, and I'm happy to take it up.
Okay, well, if only to stop me confusing myself, let's leave it until 4.3. You were a bit intermittent there, Ms. McDade. I wonder whether turning your video off is going to help, if that's okay. Okay, let's just. I think we just park this for a moment then, and we'll come back to it shortly. So that was 4.1. 4.2. Mr. Kelly, you referred to Gordon Bush decision letter in terms of need, and we'd wondered whether we had that decision, but you subsequently supplied it as CD 17.4. So I was just going to ask, can you just explain a little bit more about what you want us to take from that decision?
Thank you. I'm not sure I can help you a lot. You really need to be asking the questions of the head of the Energy Consents Unit. When I read the Gordon Bush decision letter and I got to the bottom of page 4, and I was fully aware of the extent of the John Muir Trust objection. And the decision letter says the needs case for the proposed area development is not a material planning consideration. I was quite astonished to read that, because I thought need was a key part of the argument for most renewable energy applications. Subsequently, in other objections and in other correspondence with the Energy Consent Unit, I've referred back to this sentence many times and given the civil servants concerned a chance to clarify or even refute what they say there, but nothing has come from it. So we're sitting there with a statement saying need is not a material consideration. And of course, in law, if it's not a material consideration, then it's not a material consideration. I mean, it's, as I say, the statement astonished me, but they've not taken the opportunity to refute it. And I can't go beyond that. It really is a matter for the Energy Consent Unit themselves to address rather than me. Thank you.
Okay, no, that's fine. Thank you. I mean, we'll obviously have a look at what it says. I had a brief look already. Does the applicant? Is that something Mr. Drake, you or Mr. Innes wants to comment on from the applicant's point of view?
Thank you. I think, I mean, the application for Gordon Bush was for an extension, and it was done under Section 36C of the Act. So the principle of the development at that point had already been considered. I wouldn't like to second guess what the ministers were thinking or the civil servants was thinking when they wrote it, but I would just note the fact that it was a Section 36C application and not a new application, as in the case of Section 36 at Arecleoch. The other thing I would just note is that the decision itself is dated November 2019, and my understanding is that by this time the policy context hadn't moved to its current position. The Climate Change Emissions Act hadn't been implemented. It was passed by Parliament in September and received royal assent in October 2019, and then it came into force in March 2020, and therefore the consideration of the net zero targets contained in that act didn't necessarily have the same weight in the decision-making process as would be the case now. The other thing I would refer to is the recent decision in respect of Paul's Hill, which is CD 9.21 and 22, I think. And in the ministerial decision in respect of that, the ministers make quite clear their view in respect of the weight to be attached.
Okay, thank you. We can have a look at those as well. CD 9.21 and 22. Okay.
Sorry, it's 22, 9.22 and 23.
Right.
Yeah.
Okay. If we're content, then I suppose we're just jumping back then in 4.3 to this point about consented but not yet built schemes or not built schemes, and we said in the agenda that we wondered whether this is an argument. The points we made by Ms. McDade was an argument against onshore winds in principle, or whether it means further consents are required to make up for the fact that you will sometimes have schemes which are consented but don't get built. But just on reflection, and looking at your evidence again, Ms. McDade, I wonder whether is the point you made more about the planning blight being created, if you like, by having lots of schemes consented but then not being progressed, and the kind of complications and uncertainties that cause. So I just wanted to give you, Ms. McDade, the chance just to kind of expand on that if you wanted to.
Thank you very much. Yes. Yeah, you're right. My option is neither of those. It isn't an argument against all onshore wind, and it's not an argument for more development. It's an argument for looking at what is behind that amount of consented but unbuilt. Now, Ms. Sedgwick just referred to it in her CD 15.5, paragraph 332. She gives figures for the renewable energy targets that were set in 2015 for 2020 and concludes there's a significant shortfall against the Scottish 2020 renewable energy target because these figures for operational and under construction figures equate to 13.2 gigawatts of the required 16 gigawatts. It's a fairly minor point, but the under construction is out of date because, for instance, offshore Seagreen and Murray East are well under construction and are about 2 gigawatts themselves. And there are also other onshore wind farms under construction. I know Limekiln, for instance, is one. And so just to make the point that the figure's not that far off, but the more significant point is definitely the one I was trying to bring out there, which is you have to look at why these are not going forward and whether that will be an issue in the future. And so, I do refer to document CD 23.3, Professor Gordon Hughes' research on this, and I mentioned it in my statement 45-46. And his research is done on the actual capital and operating costs for a large majority of the onshore and offshore wind farms built in the UK since 2002 that are over 10 megawatts. And his argument is that costs are not coming down, and that is a major factor. And really, Ms. Sidgwick backed that up in referring to the hiatus there's been when there hasn't been the ROCs for onshore wind. And so then you do come to the question Mr. Innes concentrated on quite a lot about contracts for difference. And so my more significant point about that is about the public good and also the reality going forward. And the applicant has, in later documents, referred quite heavily to the COVID crisis, bringing forward urgency about certain actions. But I would say we also have to consider the likelihood of how much public money will be available and how much electricity costs can be put up to support a lot of contracts for difference for these kind of developments. And if there's a limitation on that, and most of us would think there's a limitation on most public money for most things, then the UK government has made it clear that they are prioritising offshore wind. And so you're right, my point was the issue of both planning blight and also poor return for the electricity yield. And we'll come back to that with the constraints issue. So I absolutely accept Ms. Sidgwick's point that Scottish Power are not in the business of getting consents and then not building and selling it on, as a lot of other companies are doing. They want to build it themselves. But I think, as I say, if we come back to this under what the record of the wind farms in this particular area are, then the issues for planning and also the Electricity Act about giving the consumer good value. Thank you.
Okay, thank you. Mr. Buckhook, I see you had your hand up there, but I have a question just from Ms. McDade before I come over to you. How does that play into what we recommend that ministers should do in this case? Because ultimately that's what we're here to discuss. And so there's a wider point about how these things work, but how are you asking us? How do you want what you just said there to inform what we recommend?
Well, I think it is two things which are relevant to the discussions we've already had. One is the Electricity Act does have duties to provide for the public good. And from the Section 36 point of view, and I'm not a lawyer, so the lawyers can correct me here if I've got this wrong, but they do have that duty to ensure that Section 36 decisions are for the public good. And I would take that to mean all consumers, not just, but also the issue about planning blight. If this does not go ahead quickly, so that is a second issue, which is a planning issue, obviously, for the ministers. But if it does go ahead, and it will come back to this under the constraints, and they are very inefficient developments, Scottish ministers have the information in front of them to consider whether that is a likely outcome, and again, for the Scottish and UK consumers, whether that should happen or whether it's not a good development.
Okay, thank you. No, that's fine. Mr. Buckle, you wanted to say something, I think.
Yes, I just wanted to add to what Helen McDade had said with respect to the Stranach wind farm kind of series ongoing process. It's quite nearby, and this is a very real example of planning blight. This process has been going on since about 2013, and it's still not resolved. We still don't have a final outcome. And it's just sort of hanging over us, and over in the Luce Valley, and it's just sort of an immediate example of what she's talking about. And to me, I've been closely involved in this. This is absolutely unacceptable. In particular, I would unfortunately highlight the role of Dumfries and Galloway Council in protracting this process, and in my view, unnecessarily. When actually in short order, it comes a point where you need to have a yay or nay. You just can't go on discussing these things with a developer like they've been doing. So that's just an example of what she's talking about. Thank you.
Okay, thank you. I mean, obviously, yeah, I don't know anything about that, but it's a general point about the blight and uncertainty, if you like, as it affects communities with having the uncertainty. I take the point you make. I'm going to give Ms. Sidgwick the chance to see if she wants to say anything else, but for Mr. Kelly or for any of the other objectors, is there anything to be said on this point? Okay. Ms. Sidgwick, do you have anything further to say on 4.3?
No, thank you.
Okay, so we'll move on to 4.4, which is related then, and Ms. McDade's point that the case for consenting onshore wind in areas which are constrained, like this one is stated, is a less strong case than for consenting them elsewhere. So I just want to give Ms. Sidgwick the chance to respond if she wants to that.
Thank you very much. I think sort of the first thing I'd like to say is that the issue of grid capacity constraints is not a matter for determination. It's quite clear in SPP, which is document CD 7.1 at paragraph 165, which is very clear that grid capacity should not be used as a reason to constrain areas identified for wind farm development or decisions on individual applications for wind farms. It is for wind farm developers to discuss connections with the grid and the relevant transmission network operator. Grid constraints is a matter that has been recognised by the UK and the Scottish Government. If we're to look at MPF3, which is CD 7.2, it identifies as national development for high voltage electricity and transmission network. And I don't see any particular reason to think that will fall away in the MPF that is expected later this year in MPF4. I may be wrong in that, but I wouldn't expect to see that. And I think there's also ever-changing technology and storage, which I think we're going to come on to later, is a key issue. I'm aware that Corrie Glass pump storage extensions recently been consented, and that Arecleoch extension is being talked about. We do recognise that there are constraints and issues associated with this part of the world. But my understanding is that Kilgalliach in particular does get hit with downtime, which is associated with National Grid, and it's understood that it's a preferred turn-off option for National Grid because it has a large output and the constraints payments are cheaper than at other locations for National Grid. I think Scottish Power would be quite happy to see themselves being paid for the generation of power rather than for constraints payments. I don't think there's anything else I want to add at this point.
I'm just going to add one particular matter, which is whilst grid connection is in SPP terms is not a reason to essentially rule out places for future wind farm development, that in fact this project has a grid connection with a date of 2023. Now, just to be clear that in terms of the process, that means that effectively we've had to apply to potentially connect this project to transmission. That has been considered, and we come back and have an agreement as to when the project can be connected. So when we're talking about constraints, I do not want you to be left with the impression that there are constraints in this area that would prevent this wind farm coming forward, because that is not an accurate position. Grid have made an offer and we have that position, and I just wanted to make sure that that was properly set out. And I think one of the things why the planning system cannot sit prejudging what grid is about is that essentially other people have responsibility for managing the national grid, and they we've talked about the Electricity Act. They have very clear duties and there are very clear structures in place as to how they are to operate and what their objectives are. They publish vast amounts of documentation, and to sit studying grid matters, if we would have document after document after document, and a lot of it is very technical. So in my submission, that's why the planning system says it's not for us. But equally, I can say in the context of this particular application that we have that formal ability to connect and could therefore make a meaningful contribution to targets which are essentially an important part of this particular policy framework, in terms of we have hard deadlines to achieve carbon reduction. So that's all I really wanted to add on that particular point, was to give that position, and so that it was clear that whilst people talk a lot about constraints, this is not a project that is constrained.
Okay, thank you. I mean, I understand where Ms. McDade's coming from and what you've told me there. Before I see if anyone else has got any comment to make, Ms. McDade, do you want to? Is there anything you want to say just in response to what you've heard, or are you happy to leave it?
I'm certainly not happy to leave it, but I did think it came under 7 constraint payments and contracts for difference, so I'm happy to leave it till then, rather than, yeah, it's quite a significant point. I'll bench it.
Okay, no, that's fine. Yeah, I beg your pardon. We have got that later on. Does anyone else want to say anything on this matter? Mr. Bacoke, your microphone's no, you turned it off. So if nobody's indicating they want to say anything, so therefore we can just move on, I think. Okay. Okay, I'm going to move on to keep going for a little bit before we break for lunch, if that's okay. I'd hope to be further on than I can find by now, but I think the second half of the agenda should be quicker than the first. So 5.1. So Ellen McDade's hearing statement at paragraph 30 refers to load factors of around 23% here, and a UK average of 26. Now, we've noted that we saw reference to a capacity factor in the applicant's evidence, and that said that was 33%, I think. So I just wanted to know if those were the same thing or two different things, or why there's a difference. Ms. McDade, can you help me out with that?
Well, certainly capacity factor and load factor are the same thing. And I can't help you out with the 33%. What I can say is that my figures were taken from Ofgem, compiled by REF, and it's on the REF website, but they are just Ofgem figures averaged over an annual. I think that was the last annual one that was available. So it's really for the applicant, I think, to maybe clarify the 33% one.
Okay, fine. I mean, it might be that it was just because they're bigger turbines, it's an a different load. I'm not sure, but maybe yeah. Sidgwick, can you help us out?
Yeah. Hello. Yes, sir. It is the same, but the point about any load factor or capacity factor is essentially there are a number of things components that go into that. It's the particular machine's performance at a particular site, and depends on the wind resource and how the particular machines are operated, etc. So it's a site does not have a capacity factor per se. A site has a capacity factor with that machine on that particular site and how it is operated. And I think Mr. McDade's figures are probably taken from the ROC's register, which is essentially the certificates that are given for the amount of energy generated. So it won't have it won't have, for example, the constraints payments or the time which that was constrained. I mean, our general position on these sites in this general area is that over the piece they've averaged around the 26 to slightly above the 26% figure based on the technologies that were deployed at that time. But equally, there's a whole range of factors that go into capacity factors in terms of availability of turbines, maintenance regimes, etc. All those have an influence about the that capacity. So it's as I say, that's the broad position is that our general experiences has been about the average. But when we're talking about a different size of machine, that will have potentially a different capacity factor because it's sitting in a different wind resource. It's higher, and that has a direct relationship to that. So, and I think that's an important part of, in essence, this whole issue is that as we move forward, the modern larger turbines are exploiting the higher wind resource because they're on higher towers, and that's part of the efficiency that we gain from those larger machines, as well as the obviously the better electrical output because the larger capacity. So it's that combination of being higher and with a bigger machine drives the efficiency and the cost reductions that are associated with onshore wind. So it is. It's not just as simple as just saying it is a site or anything has a figure, because there's all sorts of things that go into why a particular site may be operating at a particular percentage in a particular year. And equally, as operators, operators are not particularly bothered by short-term performance. These are projects for the long term, and it's their long-term performance that effectively that they'll look at, and that's really why short-term snapshots may not be a particularly good a good measure. So now I'm going to hand over to Alison.
Thank you. Yeah, the application information refers to a capacity, anticipated capacity for the project of between 31 and 36%, and this is a figure that was provided to SLR, who were the consultants carrying out the EIA work, from Scottish Power based on their experience of the site, the wind resource data that they've got for that general area, the type of turbines that were being proposed, and the other factors that go into making up the overall picture. So the figure that's been used of between 31 and 36% is believed to be a realistic potential for the project in this site. It's not a figure that can be transferred to different projects and different sites. as Mr. Innes has just explained, the capacity factor or the load factor it varies across sites, and the types of turbines which are being used and that kind of thing.
Okay, that's fine. I'm going to give Helen McDade the chance to respond if she wants to, but I just have a further question for her. The point being made here, and I'm clearer now about why the two figures are different, or the different views for them. I suppose I wanted to ask Ms. McDade, the point being made is about the carbon benefits here, and so I just wanted to ask, does the fact that there's embedded infrastructure already, like the access track and so forth, wouldn't that would be a positive thing, wouldn't it, in terms of carbon benefits? There's some things which in this scheme you're not having to provide, and again, which you might need to do for a new wind farm. So there's that point, but also, if Ms. McDade, if you wanted to respond on anything else that you've just heard.
Your point is obvious that if a scheme does use the same infrastructure or some of the same infrastructure, that does help with carbon benefit. What we do see with these much bigger turbines is they'd have to be spaced further apart, so there is quite a lot of roads, but that has not been my remit, and I have not looked at the detail of that one. So yes, rather than building on what we might call a greenfield site entirely, that would be a carbon benefit. The points about load factor that we've just had actually make some very significant points, and I don't. On the one hand, Mr. Innes has said that there is a grid connection offered, and that will be correct because the National Grid have to do that under the current system. They can't refuse to connect something because the grid is not necessarily capable of taking that on. So yes, they have a grid connection offered. That's why the constraints issue is so important, and also that affects the load factor. So that's the connection with this particular point. The load factor for Arecleoch has been 23% for over the last year, and SPR have not disputed that. So their estimate of getting 31 to 36% may well, I would think that would be taken mainly from the new turbines specs, because we haven't seen many of these so far. But what can be seen is that if we are already getting these wind farms constrained off regularly, and I absolutely agree with Ms. Sidgwick's analysis of that, it's due to the constrainment of the grid in that area and high winds at some time. That is why these have been, and they're cheaper to constrain off for various reasons, and that will presumably not change with regard to this area. So the load factors are low. They have been low historically, and this again, much like Gordon Hughes' study of the cost of building wind farms, is based on what has happened to date rather than estimates going forward. So the load factor for Arecleoch has recently been 23%. Some of that will be because it's been constrained off. When load factor drops, then the benefit that you get back, obviously, for the grid is less. So let us assume that these turbines were built and you add that capacity. Unless SPR can say that there will be significant more grid taking this from Scotland in that area to England by 2023, the position will still remain roughly the same. Ms. Sidgwick referred to the grid connections that are being built, and I do have down somewhere where that is in her statement, but that was scaled back. The Scottish Power Connections project in the southwest was scaled back from what Scottish Power, as a transmission operator, had wished to build. And so there will still be the same constraints. And the load factor, therefore, cannot be that high at times of high wind, because you will already be constraining off these wind farms. This is a very significant point. If we're going to get the best out of each major amount of infrastructure that you're putting in, and remember that all involves remote, rare metals, the amount of steel, what's the carbon that's embedded in that. You want to get the best out of it, and that is probably why the UK government is looking at going offshore. Because although, as has already been mentioned, although they are expensive to operate, they do get a better wind resource, and they are building transmission with them at the same time. This area will still be constrained in 2023, and therefore I find it extremely implausible that that load factor will be delivered at times of high wind, because we're already constraining off to the tunes of millions of pounds the 3 wind farms in that area. And to take up Ms Sedgwick's point that Scottish Power would rather generate electricity than take the constraints payments, all I can say is that's very altruistic of them, because they always all get paid more than they would get paid if they were generating. The national grid is in a situation where it has to negotiate from a difficult point what they will pay to get constrained off. So that's good of Scottish Power if that's their position, but if it is, perhaps they should build elsewhere.
Okay, thank you. Yeah, Mr. Ennis and Mr. Buckhope, you've got your hand up as well. We're starting to stray into what we might come on to on item 7. So I'd be minded to leave that until then, unless there's something pressing. Mr. Buckhope, is it something better understood?
I just want to add to what Helen McDade said. One of the things that Gordon Hughes has talked about is the what he has observed to be the higher operating costs associated with higher hub heights. And this, obviously impacts on carbon benefits as well, as Helen has just said. I just thought that ought to be really added to this argument. The nominal higher capacity factor, may get offset by, operating costs. So I think that is a factor. Thank you.
Okay, thank you. Mr. Ennis, did you want to come back at this point, or is it something we just deal with under 7?
Just in terms of the, does it really matter? Does it need to wait to? Would you rather I waited to 7? I do think I really need to address this whole issue of constraints, but it can wait to 7 if you want to. And we deal with keep going through this because it's a sort of related issue. But I'm happy to wait to 7 if you prefer to keep going through the agenda.
Yeah, let's do that if we can. I mean, I appreciate these things can all be linked, but I wonder whether, yeah, it might be time. It might be time to stop for lunch now. I tell you what, there's one item. Let's deal with 5.2, which I don't think will take long, and then we'll maybe stop for lunch and come back afterwards. So can we have a look at what's the applicant's planning statement, which is CD 1.9 and 3.5.3. We'd highlighted this in the agenda, and also CD 1.9, and we might not have to have a look at it, but also CD 1.5 part 24, which is the carbon calculator from the EIA. But if I just look at the planning statement first of all, and 3.5.3 of that, let me just get that. Okay, so 3.5.3 is on page 23 of 74 of the PDF, if people are able to get that. And this is where the planning statement is going through the well, this is its entitled to effect on greenhouse gas emissions, and there's making some comparisons. And the first one I wanted to ask about is 59,000 tonnes CO2 per year in comparison with grid mix electricity. And then that says that would be 1.48 million tonnes, assuming a 40-year life scale. So 40 times 59,000 isn't 1.48 million. So I just wondered, is that assuming that the grid mix changes over time? Is the question for the applicant? Obviously, is that making an assumption that the grid becomes greener over those 40 years, and therefore you're not the comparison in the first year won't be the same as the 10th year and the 20th year? It's just the arithmetic that I'm asking about.
I can double check the arithmetic over lunch, but the figures that are in there are the things that the figures that have come out of the carbon calculator, which is the tool that we are required, or the applicant is required to use as part of the EIA process and to submit to the Energy Consents Unit with the application as part of that process. So I can double check the maths over lunchtime.
Okay, thank you. And I suppose the same will apply then for the second one, that how it's calculated. I mean, it's not a big point. I just want to make sure I'm reading it right. But I suppose the wider point, and maybe we can talk about this now, is that so that comparison, for example, against fossil fuel mix, I just over time the grid's going to change, and so I just wondered how valid that comparison becomes in 10 or 20, 30 years time when there's not going to be any fossil fuels, but also do these calculations assume a complete displacement of generating activity or of other generation? But if the expectation is that we'll be exporting electricity, then I just wonder how valid is it to frame benefits here in terms of displacing other generation activity, when actually what this might be doing is just adding to other generation activity rather than directly displacing it. But it's maybe something then you can reflect on over lunch, and we can maybe come back to it then, because it might be informed by your answer in terms of the calculations. As I say, I don't think it's a big point, just trying to understand the basis for the comparisons.
I can go and look at the carbon calculator and see if we can come back with a response to that over lunch.
Okay, thank you. I don't want to spoil your lunch, so if it's something that we can pick up later, then that's also fine. Okay, so that's 12:23. Is 1:15? Would that be okay for everyone to start again, or do you need a little bit longer? I'm just conscious that we've got quite a lot to still get through. Okay, let's, as we did last time, then if we just turn our mics and videos off and aim to come back again at 1:15. Thank you very much. Good afternoon, everyone. Can you hear me okay?
Yes, thank you.
We'd left. I raised issue 5. If we're all okay to start again, I wonder though before we come back to that, if maybe the best thing is just to go straight to item 7, because people and with point 1 payments, point 2 about contracts for difference, and we've talked about them to a degree already. And the question is raised at 7.1. Two things together. For both of them, we're mindful that these are contractual arrangements that are reserved matters, and they'll come after our report if they come at all. We cancel these arrangements, and we also, I think Mr. Ennis referred to earlier, the white paper has a whole section in it about contemplates long-term that we could or even should try to take into account these factors at all in preparing our report to ministers. And do you have a view on the relevance of these things for it?
So I think that was addressed to me. You're breaking up a lot from my perspective, but I'll just, yes, I have a few points on this. I suppose my first point is on your question. What is the relevance to your deliberations that you pass on to the ministers, and what the ministers' deliberations? And, you know, I would say it very specifically comes under Scottish Planning Policy 28 and 29. So, you know, paragraph 28 is enabling development that balances the costs and benefits of a proposal over the longer term. And it doesn't say over what restricted area, and I take that to be for the good of Scottish people. And it also is not allowed to allow development at any cost. And paragraph 29 obviously brings in due weight for net economic benefit. And I do not see how that cannot be interpreted as beyond what is often put forward by the developers as benefits to the local community and jobs and so on. That must be net economic development too. That's my point about the relevance of it. Sort of points specifically. So that hearing statement on these points is to be discussed at all. I mean, I think others would probably agree with me that these. In Ms. Sedgwick's hearing statement, she says that in 7.4 constraints. So they have answered, they have talked about constraints. So clearly they didn't think of your consideration. And she says Kilgalleoch has been more exposed to curtailments, 20% in recent months. This is predominantly due to competitive price and volumes of electricity that can be accessed by the national grid. And she continues, recent research shows Kilgalleoch is one of the cheapest wind farms for national grid to use for curtailment, and that's why it's top of the list. And that's certainly true. Kilgalleoch gets about £65 on average for when it's constrained off. That's to replace a £50 rock. So you can see that even Kilgalleoch does get paid more per megawatt hour always when it is constrained off. Coming back to my point before lunch about it would be altruistic of Scottish Power to be too concerned about constrained off if it doesn't cost them anything but pays them. And Arecleoch has been paid £69 when it's been constrained off on average over the last year. So again, these are not reasons for commercial developers to decide against going there. Are they reasons for governments to consider whether that would be a good use of our money through the electricity payments? That's a question which I think comes under sustainable development. But Miss Sidgwick's point about Kilgalleoch is making my point. That is my point in hearing statement paragraph 23 and 24. These developments are constrained off frequently because of the constraints. And so she's made that point when she said Kilgalleoch is constrained off often because of the locational element and the limitations of the network. So unless the network is going to be built by 2023, an extensive continuation of the network that would alleviate this, then that's a major issue. 20% of Kilgalleoch's last year's production, according to Ms. Sedgwick. And so these are not small amounts of money. That was 21 million was approximately was given to Kilgalleoch last year. And this is going up exponentially. So again, to come back to your point about why Scottish ministers should consider this, this is no longer a fairly minor national grid balancing matter. This is a matter of quite significant sums of money. We're up into the hundreds of the millions of money being spent. And so when governments come through Ofgem to consider schemes, it seems unlikely they're going to continue to consider schemes that are going to cost so much in times when, as we know, money is going to be hard to come by. So just another point on that, Ms. Sedgwick referred to the South West Scotland Connections project in the grid that's going ahead. But that was scaled back considerably from the South West Connections project that was put forward by Scottish Power. And so it will not address all the wind development that you're going to get on a good day in that area. And I would refer to the document I lodged about the Hunterston link, because Ms. Sidgwick also refers to that link. In my statement, I referred to the document CD 2313, which is a detailed assessment of whether the Hunterston-Wales link has addressed the problem that it was thought it would address. And it hasn't, as we've seen from the figures there. So the relevance to the ministerial decision must surely be that the UK cannot continue to subsidise such high constraints forwards, exponentially increasing, and decisions on subsidies are bound to take that into account. So that is about planning blight very specifically. I'm sure Scottish Power would hope this would go through quickly and that there might still be some money for onshore wind in that area. But I think ministers have a duty to the whole country to consider the planning blight that, as has already been referred to by Mr. Bucock, in the area. Why is this area so developed? Why are there so many applications coming forward when they have poor load factors and when they're getting so much constraint payments? And, I would suggest follow the money. They are getting 10 to 15 pounds per megawatt hour extra every time they don't produce. It's good money. So I totally disagree with Mr. Innes that this is not a matter for Scottish ministers. And I think it would be a disgrace if it wasn't, to be honest. So, yeah, sustainable development, net economic benefit would be the points I would make. And I think the figure of load factors coming forward was highly speculative. But if it was correct, it cannot be taken out from the grid with all the production that's already there. The figures just show that. Thank you.
Okay, thank you. Yeah, I noted the earlier exchange on load factor, so I got that. And in terms of the point you were making there, I'll allow others to come in a moment, but just to paraphrase, it seems to me there's two sides to it. There is the relevance for you insofar as this should all be taken into account in terms of the net economic effect, but also a kind of subsidiary point about planning blight insofar as you could consent this, but for whatever reason it might not go ahead. For example, for want of lack of financial support, and so it's relevant because that might mean you get a consent that doesn't go ahead. You get blight, so that's fine. Do any of the other objectors want to add to that, Mr. Kelly?
Thank you. I must admit, when I first read the last sentence in your paragraph 7.1 of the agenda, it brought quite a wry smile to my face, because I've twice recently discussed constraints payments with the head of the Energy Consents Unit. And your last sentence is almost verbatim, in fact, it is verbatim what he said to me on both occasions. So I'll be generous to you and assume that the head of the Energy Consents Unit hasn't asked you to ask that question of me. But let's get serious on the issue. Of course, it's relevant. The constraints payments are paid by electricity bill payers, consumers. Therefore, it's part of the net economic assessment, both in terms of direct cost and in terms of the opportunity costs, the expenditure lost that would have been spent on something else. It's also, constraints payments are also illustrative of a benefit foregone. If you make the assumption that the principal benefit of a wind farm is so-called green electricity, then it's only providing green electricity when it's generating and transmitting to the grid. When it's constrained off, therefore, that is a benefit foregone. And thirdly, one that's always intrigued me as to why some planning decision makers think renewable energy is this kind of strange, different, separate form of development. It's simply a planning infrastructure issue. Let's look at something else. Say you were considering a major housing development instead of this major wind farm. If you knew, for example, that the road network out with the housing development site was already severely congested, causing environmental and economic costs, you wouldn't consent the housing development without that issue being addressed. And I don't see why it should be any different for renewable energy. There is environmental and economic costs associated with this. So I think it's a very straightforward issue. It is relevant, and as Mr. McDade said, it fits directly into Scottish planning policy. So it shouldn't be ignored. Thank you.
Okay, no, thank you. You haven't shown, I'm not aware of any, I'll come on to you, Mr. Cook, in a minute. I just have a question for Mr. Kelly. Are there any ministerial decisions in Section 36 cases that you can point us to that deal with those issues in that way, or that will guide us as to what if ministers have taken a view before and whether this is relevant or not?
As I understand it, there are none, because, as I said at the start, the position of ministers, as has been explained to me, is what's set out in your paragraph there, the last sentence. They claim it's nothing to do with them, which I think is just planning nonsense, absolute nonsense, to try and perpetuate that view.
Okay, that's fine. Mr. Buckhoak.
Just wanted to add something to what Helen McDade was saying about capacity factors. Unofficially, I heard that the EDF team were looking for 30% capacity factor for Stranraer 2. That was their target. So that might be of interest to some others. Thanks very much.
Okay, thank you. Are there any other points on behalf of objectors or the council before I go back and see if the applicant wishes to respond? No. Okay. Ms. Sidgwick or Mr. Innes, do you want to come in on 7?
Yes, thank you. If I could first of all respond on the capacity factors which we have been discussing and have been raised. In terms of the range 31 to 36, those are matters which based on Scottish Power's analysis of the site, we've got 2 wind masts up, and effectively Scottish Power has its own team that deals with both operating wind farms and looking to the future as to how future projects will operate. They have extensive experience in dealing with these matters, and they have very clear data and predictions as to what they think the performance of the type of turbine that they would procure for this site would be. So in terms of the estimates, they are soundly based and undertaken by people with very extensive experience in relation to predicting these matters. And equally, it is based on direct evidence relating to the wind resource on site, and that's reflected on the fact that we've had masts up and analysed that data over a period of time to give us an accurate indication as to the likely capacity factors. I'm now going to deal with the issue of grid, which is quite frankly the ingenious attempts to get around the planning policy. It's very clear. Paragraph 165, grid capacity should not be used as a reason to constrain the areas identified for wind farm development or decisions on individual applications for wind farms. It is for wind farm developers to discuss connections to the grid with the relevant transmission network operator. Consideration should be given to underground grid connections where possible. Now, in terms of the this issue, I'm going to start with the project. The project has a grid connection, so we've done the second part of paragraph 165, and we have been given a grid connection date of 2023. What that tells us is locally, this wind farm is not constrained. If there were constraints applicable to this wind farm, we would have a longer connection date and we would be told that reinforcement works would be necessary for this project. That is not the case. And equally, we've got a very short grid connection to the Mark Hill wind farm, substation, which is only just over 2.5 kilometres away. So that's a very positive thing in terms of grid connection relative to this scheme. And what it does build upon is it's correct to say that Scottish Power Energy Networks have invested considerably in the southwest of Scotland in improving the grid position. And that's reflected both in terms of the connections, but also critically in terms of modern substations, which are capable of accommodating the connections for the wind farms that were anticipated to come forward in the southwest of Scotland. And that's a clear example of the actual grid infrastructure for this project is available. It's available over a very short period of time and is in fact a very positive factor that weighs in favour of this project being able to deliver and respond to targets. So I now turn to the general discussion on constraints, which in my submission is irrelevant, but I better respond to it given others have. Can I make one first point? Constraint payments provide a zero premium to the owner-operator. The payment reflects the lost revenue and associated costs. This is appraised by National Grid and delivered on a transparent basis. If it could be done cheaper by us or others, then they would curtailed less. So effectively, what we're saying is the reason why Arecleoch is being turned down is because it is cheap to turn off, not because there's some wider constraint that is having to turn Arecleoch off in terms of the area. It is wider grid constraints that cause the issue, not the local ones or the local network. This is a much bigger issue, and as has been alluded to, there are wider issues in the strategic network, which over the past few years continue to prove challenging. And reference has been made to the Western Link. That's a 2,200 megawatt, 600 kV HVDC link from Hunterston down to Flintshire Bridge in North Wales. And this is a part of a modernisation of the UK grid and is supposed to improve flows. Now, there have been some challenges in terms of the reliability of that link. And that is one of the reasons why there's potentially some higher constraints payments. but that is not something that falls back to an individual project. That's a matter for National Grid to ultimately manage. And there'll be changes, and no doubt there'll be other changes. And for example, Hunterston B, a nuclear station to the north of these projects, is due to come offline by 2022. So all these things will change how the grid and the flows operate. And the idea that somehow an individual planning decision is the right method to try and resolve grid issues is, in my submission, not right. And simply put, there is no evidence to say that this particular scheme suffers specific grid constraint disadvantage. In fact, all the evidence suggests the alternative. And it's perhaps quite important to just take a step back and say, well, what is this whole grid about? Well, the fundamental part of the Electricity Act was actually to promote new entrants into the markets. And one of the markets that we do have in UK is generation. And the generation market, before we left the EU, was deemed so competitive in the United Kingdom that it was no longer subject to public procurement requirements. So the key part of grid is facilitating competition, facilitating people getting on the grid. And part of that mechanism is that as a developer, we pay a cost to connect, and then we also pay significant charges to use. So it's not, when we're looking at the constraint payment, effectively, that is a payment back for the non-performance of our grid connection. And in any system, somebody has to carry those risks in terms of grid. And it's been chosen that in relation to grid risk, that is contained at that strategic national level, and that is where the cost is borne. If it was left for individual developers to pick up grid risk, effectively the ability to bring forward projects would be severely hampered, because effectively we would be taking a risk in bringing forward a project, not only on the project economics and building it and operating it, we would also play or have to take the risk of potentially grid constraining out. And that would be a massive significant risk, which would add to the risk to bringing forward new generation. So that's already been decided by Parliament, by others deal with grid. It's regulated, and everyone needs to be given fair and transparent access to the grid system. But it has nothing to do with individual decisions on individual projects. And that is replicated in the SP, and there's a specific reason for that, is that there's no way that we could be here for months, or that we discussed all the ins and outs of the grid system. And still, it wouldn't be for this decision maker to make any maths on those grid, because that's a matter for National Grid to resolve. So in my submission, there's sound reasons both in the Electricity Act and the way in which it's structured why these matters are not right and not proper to take into account. And on any view, when we actually analyse the specifics of the grid in relation to this project, far from being a negative, it's a major positive for this project that it has a grid connection and can be brought forward in short order. And it's actually taking account of the already significant investment that grid has made in the area to be able to facilitate exactly this type of project and to enable its connection. And in my submission, it's a positive far from a negative. And I think I don't really have anything further on this matter. Thank you.
Okay, thank you. I mean, I think we have a clear understanding of where each party's coming from. Helmy, David, if you get a hand up, so I'll come back to you in a minute. But Mr. Campbell, you, I got a message to say that you had to drop out and reconnect. I'm not sure you've missed anything directly relevant to the council's case, but Mr. McGibbon can confirm if that's the case. But I don't think you've
to be heard on this topic. I'm afraid I live in a part of the borders where the internet supply is variable, and we had a momentary cut of some sort, but it seems to be fixed now. Sorry for interrupting.
No, not at all. Just making sure that you're not missing out. Liz McDade, did you want to, as I say, I mean, I think I do understand where people are coming from, but if there's something else you feel has to be said, then by all means.
A couple of quick points on what Mr. Innes.
Ms. McDade, I wonder,
made some considerable argument there that the estimates put forward are very accurate.
Ms. McDade, we seem to have problems with your connection, so I wonder, apologies, could you maybe just turn your video off, and we'll see if that helps. And maybe if you do, maybe repeat that point.
Sorry, I'll turn my video off. With regard to Mr. Innes's point that the constraints and the grid is far too big an issue to be discussed at individual application level, I think that would carry more weight if we didn't spend a lot of time discussing what it means for EU targets and UK targets and so on. I think we are talking about how it fits in the wider context. So I don't think, and I've already said why I think it fits into Scottish planning. And although grid capacity should not be, according to SPP, saying not a factor to be taken into account, sustainable development and net economic benefit is. So you would have to find a way to eliminate it from that. And yeah, so that's all I wanted to say on that. Thank you.
Okay, thank you. I didn't hear.
Sorry, there was one point he said that I did want to actually just contradict. He said that they do not get paid more when they're constrained off. They do get paid more by about £15. So, I mean, the figures are there. Arecleoch got paid £69 per megawatt hour last year for constrained off. They get about £50 in the rock. So it's very clear there is a benefit there. And that affects the load factor. So the two things, the more they're getting paid for constraints, the less the country is gaining in that sustainable electricity production, as Ian Kelly pointed out. Thank you.
Okay, thank you, Ms. Meady. You mentioned Black Start as well yesterday, so if there's a point you want to make about that, we may as well deal with that now, and then give the applicant a chance to respond if they want to.
Yes, thank you. Thank you, Mr. Little. Yes, so the point about Black Start is raised by the applicant. So this is another national issue which Mr. Innes might have argued was not relevant, but it is put into Ms. Sidgwick's statement at paragraph 7.3.7 to 7.3.9, and it describes a trial to see whether you can black start the grid. And I think probably by now most people understand black start means if a large bit of the grid drops out for frequency reasons, then it needs what's called the black start. And this has always been one of the difficulties about increasing reliance on uncertain renewables. And so this experiment, as I see it, was conducted to see whether the grid part of the grid could be started from a wind farm. I would just say there's no detail given on this. I went to the climate change plan and looked at page 77. There's no detail given about what that is. I understand it cost 550,000. I'm not quite sure, but that was a figure given. 550,000 was spent on maybe not just this trial alone. This is obviously a trial, and no details given about what kind of thing was involved. However, as I understand it, for wind farms to be used for frequency control, if a wind generator is to be used to control low frequency, they would have to be operated below the low power, the real power output, so that they could be stepped up. So the reduction in power would have to be 100% of the time. This is the information I get from somebody who is a director of National Grid. So that would decrease load factor and increase levelized cost. So that's slightly speculative because there's no detail on it, but I would ask the reporters to ignore that section of Black Start. But if not, I certainly would request that that information from a former director of National Grid is taken on board. You would not be able to operate at the levels that Mr. Innes was discussing there and use it for that. That's my understanding. Obviously, this came in at late notice, so I couldn't put a paper in on it. Thank you.
Okay, thank you. So just to make sure I understand it, and I'll come back to the applicant in a minute. If what your understanding is that if you were going to use the the wind farm for Black Start, then that would affect its ability to deliver, or it would reduce its overall output over the piece. Is that shortly? Is that what you're saying to me?
That is what I'm saying. That is my understanding from the information I was given. Thank you.
Okay, thank you. Ms. Sidgwick, do you want to say anything in response?
Yes, please. I'm unaware of what Ms. McDade is talking about in terms of those figures. Really, the point of putting that information in was to highlight the sort of continuing evolution that electricity and onshore wind are doing to try and address some of the problems that have been associated with onshore wind and renewable energy generally over the years. It shows that the industry is continually evolving and trying to address known problems and things, and it provides a potential solution going forward, and it shows that the government is still keen to invest in onshore wind. I understand that government money has gone into this, so they are continuing to invest in the evolution of onshore wind. And that was really the only point in putting that information in.
Okay, thank you. Unless there's anything else on that, I'll maybe just go back then to item 5, and Ms. Sidgwick, you were going to have a look at the calculations, some of the stuff from the carbon calculator, and maybe just provide a bit of clarification if you were able to.
Indeed, yes, thank you very much for the opportunity to do that. I've looked at the figures that are in the EIA and the planning statement that supported the application, which have then been transposed forward into my documents, are based on generation of 25 years and not 40 years. If they are to be looked at in the context of 40 years, the figure of 4.85 million would be 7.76 million. The figure of 1.48 million would increase to 2.36 million, and the figure of 2.42 million would increase to 3.87 million for 40 years. And so the first figures, if you like, in those bullet points are correct, and they're the ones that are contained in the information on the carbon calculator, which is found in the technical appendix to which you referred earlier. And the capacity factor in there is 33, which is Mr. Innes has explained, based on Met Mass and Scottish Power's working knowledge. You asked about the grid mix and the potential for it to be ramped up or down to reflect the changing mix in energy generation. I don't believe that it does include that factoring as part of it, but we can confirm that later if that's of assistance. But I think it assumes a flat rate, and therefore it provides a sort of snapshot at time, as it were, because the carbon calculator is updated on an ongoing basis.
Okay, thank you. So it's it is a 20. Well, it should have been a 40 times calculation, rather, but it was a 25. That's fine. That makes sense. And I suppose, would you accept though that there is some difficulty in just multiplying the current benefit in year 1 by 25, because it's going to change. It's going to get cleaner over 25 years.
Indeed, it will change. It was just a sort of mechanism of ramping it up, if you like, to show the over the time period of an operational lifetime. Of course, we're talking of it's 25 or 40 years there. What Scottish Power would like is for this development to be in perpetuity, so that the ongoing benefits are maximised for as long as possible.
Okay, thank you. That's fine. It's just a point of clarification. Does anyone else get anything to say on this point, or shall we move on? Okay, bear with me a moment. Okay, so item 6 then was energy storage. Well, as we said, I don't have any we don't have any particular follow-up questions, but I just wanted to give the opportunity, either Mr. Buckoak or Mr. wanted to comment. Mr. Buckoak, you first of all, is there anything else you want to add to what you've said already?
No, I was just, endeavouring to establish that, these matters, the amount of storage, really does need to be made clear by these applications, because this is obviously going to be a very big subject in the near future. The assumption being that the capacity offered is in the kind of short-term range, well, sort of 4 to 6 hours typically. And as I said, this is really a sort of smoothing, grid stabilizing application, really. I mean, it's not actually really medium or long-term storage. But I think I would also point out that the whole question of medium and long-term storage is, very much in its earliest infancy, as the Jacobs report makes absolutely clear. We don't really know, how much storage we're going to need, and I think the CCC report as well, the 6 carbon budget, also touches on that. We're in an early stage here. We haven't even got, for example, a market for this kind of storage established yet, and that's one of the things that the Jacobs report discusses. But I think in general terms, having looked at some of the figures involved, I think that these various reports greatly underestimate a future storage need, and that's what quite a few commenters on this matter have concluded. We're going to need a whole lot more than people realise. So, yes.
I'm sorry, Mr.
Can't hear.
I'm sorry. My apologies.
Right.
You're talking there about long-term storage.
Yeah.
Why is that relevant for us for this application?
No, I mean it's the short-term figure was necessary in a context. That's all I was saying, really. So I think it's important to realise what that context is, and to supply figures which give the right information about what's being talked about. As I said, this does have quite big cost implications, but I think the public do deserve to know about these things. And make sure you get the units right and what kind of thing you're talking about. Yeah.
Okay, thank you. Ms. Sidgwick, have you got anything further to add?
No, nothing further to add. Thank you.
Could I just add one more point to that, if I may? It seems to be quite a lot of consensus that batteries now are quite good for this short-term application, and that's reinforced by the Jacobs report. I mean, they're quite good figures pointing in that direction as that being that's sort of fairly optimal in this short range. So I think that's just sort of relevant that the size of battery involved is supported by a general consensus there. It's very different, though, I would say, for the medium and long-term storage. So I think that's really all I've got to say there. Thank you.
Okay, thank you. That's fine then. Let's bear with us. we'll find where we are on the agenda. So, right, if everyone's happy to move on, that takes us to item 8, which is, well, 8.1 is about Scottish planning policy. And you might have noted that an updated version of the SPP was published on Friday, the 18th of December. We provided a link to it, but the applicant has helpfully added it now as CD 7.15. Thank you. On quick glance, so the policy material, Ms. McDade, you were referring to paragraph 29, I think. There's the policy on wind. I don't think any of that's changed, but I just thought we should give you the opportunity to address this if there's anything about the updated SPP that you want to mention. So I was going to go to the council first as the planning authority. Have you had a chance, Mr. McGibbon or Mr. Campbell, to take a view on this?
Yeah, we don't think there's any change necessary. I mean, essentially for us, I think the key issue is sustainable development, and that's still, the principles of sustainable development remain unchanged. So yeah, we've got nothing further to add.
I agree with that.
Okay, thank you. Mr. Kelly, do you have view on this?
I must admit, when I looked at the new version, I struggled to find the changes in text. I wish they'd used a different colour to help us all. But I agree with what the council says. It doesn't change any matters for your consideration of this application.
Okay, that's fine. Unless any of the other objectors want to say anything in that, I'm just going to ask Ms. Sidgwick or Mr. Innes for their view.
Thank you. I mean, I would agree. I don't think it changes anything. And I think in terms of paragraph 32 and 33, the tilted balance doesn't come in the context of the section 36 application.
Okay, thank you. So 8.2, we've touched on it already in terms of some of the earlier evidence on sustainable development in paragraph 29 of SPP. So, I mean, I think we're reasonably clear on what people are saying, but we just maybe wanted to give parties a chance to expand a little bit. So, Mr. Kelly, for example, paragraph 95 of your hearing statement, you identify 5 of the principles which you say will be offended, and you therefore conclude that the proposal wouldn't contribute to sustainable development. I mean, it's clear enough, but is there anything that needs to be added to that, or does that still fairly summarise your position?
It fairly summarises my position. It is, of course, only my position. My view would be that it's for the reporters in writing up the report to conduct the same exercise and go through the same criteria and form their own view. But I don't have anything to add to my earlier assessment.
You're not muted. You're muted.
Apologies. Mr. Kelly, you also refer at paragraph 96 to Altdoon decision. I don't think that's been put before us. Is it an important point that you wanted us to take from that?
No, you don't need to see it. It just links to the same issue. It just references the fact that ministers have reached a conclusion on another case that it didn't form sustainable development. The context there was an assertion at the time that wind farms by definition must be sustainable development. So the point was dealt with there, but it doesn't detract from applying the tests in the SPP, as I said earlier. So you don't need to see Altdunia to reference this point.
Okay, fine, thank you, that's helpful. And Mr. McGibbon, your evidence in relation to paragraph 29, or your position, is it to the council committee report that we're best looking at in terms of your view on this?
Yeah, I would say that most of the sessions contained within the committee report, also within the hearing statement as well. I'd just kind of like to add a few things as well. I mean, there's things that I've got written down that I don't think I'll cover, because I'm sure you're aware of it within the committee report. In terms of, obviously, we don't consider it to represent sustainable development, and the reasons are obviously outlined within the committee report and the hearing statement. But I would like to stress that for the council's point of view, we're obviously not against kind of wind energy. That's a kind of important point to stress. There's been several applications for wind energy that's been they didn't object to, and some of them are Mark Hill, the original Arecleoch, the Glen App, Kilgallie, Chermorey and Strannoch, albeit Strannoch and Kilgallie are actually the turbines within Dumfries and Galloway. But we think it's very much driven by the right development in the right place. It is obviously driven through national policy and comes through local policy as well. And obviously, from our point of view, we feel it's this development that's coming too close to the intimate pastoral valley, because obviously from the landscape character type, which is obviously within a document that we'll probably come to later on, the wind capacity study, that obviously says that the turbines should be located more to the core as opposed to the periphery. Now, clearly this application is coming more towards the periphery, which again is the concerns are outlined within our panel report. Another couple of documents I'd like to draw attention to as well would be document CD 16.6 and CD 16.7. And that's for the Altercanoch. That was the first one's the report, and the second reference there was the decision notice. Now, that was for 8 turbines of 131 metres, and they were located just about a kilometre south of Barhill, very close proximity to this one, and we feel that there's similar issues between the applications. The council actually refused that application on 16th of November 2017, and the appeal was subsequently dismissed on the 1st of March 2019. Again, the turbines themselves are located in the character of the Plateau Moorlands forestry and wind farms, as is the case with Arecleoch. However, it was deemed by the reporter and indeed by the council that they were too close to the intimate pastoral valley. And again, this is the decision that obviously it's not, you've got to weigh the balance in sustainable development in terms of the overall weight, given all the principles to the actual development as well. So it was basically deemed that the balance of all the perceived benefits and all the SPR will say the job creation is obviously one of them, but the perceived negative impact in the landscape was deemed to give more weight than the perceived benefit. And as I say, because of the proximity of this Altercanoch refusal, I think it's very similar to this proposed extension. And indeed, those turbines are 131 metres. Obviously, these turbines are 200 metres. So you could argue it's even more of an adverse impact on the Pastoral Valley. I know I don't want to get too into the landscape and visual side of things, so I think I'll leave it there. But as I say, we just want to stress that the council certainly recognise the need for sustainable development and indeed for wind energy, but we just feel that the area is really is getting kind of to capacity, I would say, in terms of the Plateau Moorlands landscape character type, and just going too close to the periphery. So we certainly don't feel that it represents a sustainable development. But as I say, most of the reason for that is outlined within the panel report.
Okay, thank you very much.
Can I just add to that, sir, please?
Yep.
For the council, since Mr. McGibbon has spoken to you, Mr. McGibbon, is it? Can I just ask him through you, sir? Correct that the policy for sustainable development in the local plan is on, I think, page 4 of the local plan. Is that right?
Yeah, that's correct. Actually, I should talk about that, because obviously one of the principles of the sustainable development within SPP talks about the land use. So obviously, from the council policy on sustainable development, it sets out our principles for sustainable land use, and some of the key considerations just outline: be appropriate in terms of its amenity impact, layout, scale, massing, design, and materials in relation to its surroundings. Respects the character of the landscape, respects, protects, and where possible, enhances natural, built, and cultural heritage resources, helps mitigate and adapt to the effects of climate change, protects peat resources, and does not have a negative effect on air and water quality. And as I've just outlined, after assessment, the council feel that we couldn't not object to the application just because it wasn't in accordance with these some of these key principles of sustainable development, mainly due to its massing, the non-respect to the character of the landscape, and certainly having an adverse impact on the kind of natural environment as well. You know, because obviously latterly the public water supplies, which was a later addition, clearly that kind of falls into this as well, and is also a concern for the council.
Okay, so those criteria are all picked up in the policy, are they, one at a time?
Yes, they're all outlined within the policy. So I should explain as well that why I'm looking up to my left, because that's where I can see you all, because I've got 2 screens and my laptop's got my camera on it, so I'm not kind of looking squintly.
So just for your notes, so the local plan is CD 3.1.
That's correct, yes.
Point 10.
The CD 3.10 is the panel report. Yeah.
Panel report, sorry, report of handling. Yeah.
The policy and sustainable development is the local development plan, which is CD 3.1.
And I think you're supported in these conclusions, are you, by Miss Robertson, Miss Anderson, and by Miss Connie Lobban?
Yeah, that's correct. Obviously, at a later date in the hydrology and public private water supplies, Constance Lobban will be speaking about that. And the council's witness on landscape and visual matters will be Carol Anderson, who obviously was a key kind of consultee for us internally in terms of our response to the ECU.
Okay, thank you. No more, sir. Thank you very much.
Okay, no, that's fine. Thank you. And similarly, I've got here as well, so that's why I'm occasionally looking to the side. Okay, unless there's any other point on SPP that any of the objectors want to make, I'm gonna see if Ms. Sidgwick wants to respond on that point. You went into what the local development plan says there, and we've got that at, I think, item 10 in the agenda. So, Ms. Sidgwick, if you can maybe park any discussion on that until a little bit later, and I just want any response you might want to make in terms of what you've just heard there about para 29 of SPP. But as I say, if you should need to just tell me again what's in the written materials, just if there's anything additional you want to say. Thank you.
No, in terms of SPP and the sort of presumption of sustainable development, our position is that the presumption is engaged and that the proposed development is a sustainable development. Scottish ministers have found that there are plenty of wind farms which are sustainable development. They have also found situations where the presumption has not been engaged. I certainly don't say all wind farms are sustainable, but in going through the criteria or the various matters that are set out in the bullet points in paragraph 29, I come to the conclusion that the proposed development would constitute sustainable development. I would like to respond on some of the stuff on Arecleoch, but I'm happy to wait till later on in the agenda on that, if that's what you would prefer. I'm afraid
No, yeah, no, that's fine. I'm happy to do that now. The only caveat I would say is that obviously that's reports are a different development, and we're going to have to reach our own conclusions on this, Alison and I. So I'm not convinced a detailed discussion of that is going to help us much, but it has been raised, so by all means, respond.
Yes, I mean, I would absolutely say it's not the same site. It's a different landscape character type. It's a different scale of turbine. And my position is that each application should be considered on its own merits. And I note that the reporter in paragraph 21 of the Arecleoch report says this appeal must be considered on its own merits. And I would suggest that Arecleoch should also be considered on its own merits.
Okay, thank you. If people are content, then I'm going to move on to item 9, which is National Planning Framework. So I can hear a bit of feedback. I can hear my own voice coming back again. I don't know if somebody's... Yeah, that's better, thanks. So yes, we don't have any questions about the National Planning Framework, NPF3, and although Ms Sidgwick refers to prospects for NPF4, we don't have any questions about that. But I just wanted to give, if anyone wants to respond on that point, I want to give them the chance to. I think Mr. Kelly, you made the point that one shouldn't speculate on what might or might not be an NPF4, but beyond that, is there much more to be said?
Yes, I previously referred to the no decisions have been made, and the current, it says on page 6, the current NPF3 and SPP2 remain in place until NPF4 is adopted by ministers. The NPF4 position statement is, again, a very wide-ranging and interesting document. One thing that I took from it, it appears several times, but it's highlighted on page 18, and that is, moving forward, ministers intend to promote an infrastructure first policy. Now, it doesn't say that they intend to promote an infrastructure first policy for everything bar renewable energy. It's not excluded. So you can see that that is a very sound principle in relation to what we've been discussing, infrastructure first. But of course, again, we don't know what the final version of NPF4 is going to say. So I wouldn't want to ask you to put any excessive weight on that, but it is an indicator of their forward thinking, and it's very clear, promote an infrastructure first approach. Other than that, I have nothing else to add. Thank you.
Okay, thank you.
So I wonder if I might just offer a word of caution about that document. I had the privilege of attending a seminar with Mr. McNerney, the chief planner, not very long ago, and he was at pains to point out that whilst this position statement should be taken for everything that it says, it is not, repeat, not necessarily an indication of what ministers are going to do. It is simply an indication of current thinking amongst officials. And so he was, I don't wish to devalue what Mr. Kelly said, which was indeed an important contribution to this examination. But the position statement doesn't have weight as, in my submission, doesn't have weight as pointing one way or the other in relation to this application. Mr. McNerney was very at great pains to say it lies on the table as a neutral statement of what we're all thinking. But beyond that, he was cautioning us not to go further. And I know cynics will say, well, government always do this, but you can't proceed on that basis, sir. It must be regarded, if I'm right, must be regarded as a neutral piece of evidence.
Okay, well, we can reflect on that. Ultimately, ministers will need to determine how much weight they want to give to it. Okay, if there's nothing else then on NPF, we can probably move on. So I'm just looking at the time. I think we're still good. Is everyone okay to continue just now without a break? Well, I'll give you a break, but is everyone okay for the time being? Yeah. So item 10 then says conclusions on national planning policy. And Alison Sidgwick sets out her position in paragraphs 5.4.1 to 5.4.5. And so, yeah, we just wanted to know, I think I know what the answers are going to be, but do other parties consider there's been a change in policy support for renewables since Scottish planning policy? Well, that's now 2020, of course, and the third national planning framework. Mr. McGibbon, has the council got or have you got a view on this point?
I would say no, would be my answer. There's been no change. As spoke about yesterday, there's only 6 paragraphs that were changed in SPP, so.
The fact that you'd say that adds weight to that view that the policy is still the same.
In terms of this, yes. Unless John wants to.
Mr. Campbell, have you got anything to add, or are you happy with that? Okay, Mr. Kelly.
I was not coming in because I'm quite happy with the answer. I don't have anything to add to what Mr. McGibbon said.
Okay, Mr. Kelly, I think you already said as much, but I'm just going to give you the chance to respond to the hearing statement if you want to. But I think I understand your position clear enough. Anyway.
I have nothing further to add, sir, to what you already have in writing.
Are there any other points to be made in this from objectors before I see if Ms. Sidgwick wants to respond?
Yes. David?
Yep, carry on.
So just a quick point, because current policy has been clear, stronger than an SPP public 14. Instead of SPP being the same, more or less. But I would refer back to, because there's a lot of discussion there, 2 paragraphs in this 2032, and they're so 319 and 3110 say general storage, such as pump storage, net that's fair enough, but I would say storage at Corrie approved recently. Well, it wasn't recently, it was several years ago.
I'm sorry again, it's just you're coming in and out, so maybe if you turn the video off. I heard you refer to 3.1.9 and 3.1.10, but I wasn't sure what document that was from, so maybe if you could just repeat that. Do apologies.
Okay, sorry, I should have switched my video off. I'd forgotten. CD 8.32, the update to the Climate Change Plan 2018-2032. So those 2 paragraphs, 319 and 3110, are about key energy infrastructure, including electricity generation, large-scale storage, such as pump storage, hydro, development of the high-voltage electricity transmission networks and the CCS network, are all being considered in preparation of the fourth national planning framework, and Ms Sidgwick referred to this recently. On her point that she mentioned that, for instance, the pumped storage Corrie Glass had recently been approved. In fact, Corrie Glass was approved several years ago, and as I understand it, there is nothing happening there. And again, this comes back to why it is important for Scottish ministers to consider the reality of what may or may not be funded. And then the next paragraph, 3.1.10, says, so this is a Scottish Government climate change plan. However, two of the key levers needed to release Scotland's further renewable energy potential, electricity policy and regulation, are reserved. This means that achieving our targets critically depends on the UK Government taking the right decisions and actions and acting urgently. And so my point is I do not agree with Ms Sidgwick's assessment about UK policy, and that then leads us back and indeed, the pump storage point backs up Mr Buckock's point about energy storage, so I should probably put it in there. But since I won't be putting closing submission in, I wanted to make sure that point was made, that the Scottish Government recognise UK policy and decision-making on this is relevant to their decision-making. So that's fine. Thank you very much.
Okay, thank you. And sorry about the continuing connection issues you're having, but we can certainly hear you fine when the video's off. Ms Sidgwick, do you want to say anything before we move on?
Yes, could I say a couple of things, please? Just responding to Ms McDade's comment, it was not Corrie Glass that was consented recently, it was the extension to Corrie Glass which was consented towards the end of last year. Apologies if I caused confusion on that one. Just going back to the comments made by Mr McGibbon, my understanding that the SPP was changed, the errata only looked at a specific issue following on from the consultation that happened in the sort of late summer, autumn of last year, which in turn followed on from the Gladman case and the issue of the tilted balance and sustainable development. It was not a review of SPP, and therefore it would not have sought to update the references to targets and the like. So therefore I would go back to what was said in the Pools Hill decision letter, and that there has been a clear step change since 2014 and the publication of the SPP.
I'm sorry, I don't wish to be rude, but I don't understand that. Is the witness saying that there has been, is the witness saying that there has been a clear step change in 2014 or in the 2020 amendment?
Sorry, no, what I'm saying is that there has been a clear step change in the weight to be attached to policy, which is the sort of some of the conclusions I'm coming to in section 5.4 of my hearing statement. It's not a step change between the 2014 SPP and the 2020 SPP.
So that would, in my submission, lead us into a discussion about the difference between policy and guidance. You may not wish to go there today, but you're shaking your head. Well, fine, I'll leave it there. Sorry, you're still muted.
I beg your pardon. And just so I'm clear, you would point us towards the Pools Hill decision for an expression of the differing weight now to be attached.
Indeed, sir, as set out in the 5.4 of my hearing statement.
Okay, that's fine. Thank you. Yes, I'm sorry about disappointed you, Mr. Campbell, with my shaking my head, but it's maybe a discussion for another day.
Another day, perhaps.
Perhaps we can take a break now. Then the next item is number 11, which is the local development plan. So it's 2:25. So if we can be ready to start again at 2:35, everyone, if that suits everyone. Okay, thank you very much. Okay, welcome back everyone. I'll resume again if everyone's ready. We had reached item 11 on the agenda, which is about the local development plan, CD 3.1. And we don't have any questions. You understand what people are saying to us. We are not, I'm not encouraging a discussion today about the extent to which the proposal complies with the development plan or doesn't. That's ultimately something Alison and I will have to consider when we've heard all the evidence. But I just wanted to give you the chance to respond to the other parties' hearing statements if you wanted to. Firstly, for the council, Mr. McGibbon, you've already talked a little bit about the sustainable development policy. Is there anything else you want to say beyond what's in the written evidence?
Yeah, we've got nothing further to add than what's in the panel report and in our hearing statement.
Okay, thank you. Mr. Kelly, for you, is there anything?
No, sir, nothing further to add to what you already have in writing.
Okay, thank you. And what about, do any of the other objectors want to say anything more about the local development plan?
David, you're on mute.
Terribly sorry. So that's fine. Ms. Sidgwick, the only outstanding thing I've noted then on from today from the LDP was what Mr. McGibbon said before the break. Is there anything you wanted to say in response to that?
No, sir, I think I responded on the Altacana issue, which was really the only other thing.
Okay, thank you. I should have said I've got a few items to go through. I'm hopeful we'll get through them today. But if anyone needs to go at a particular time, then please just let me know, and we can see. Hopefully we can get things done before people have other commitments. But let's see how we go on. So item 12 was about the supplementary guidance, and it was about peat. I think this is what Ms. McDade referred to yesterday. And I think Ms. Sidgwick's point was that if the supplementary guidance had used the same data that SPP says it should use, then its mapping of peat would be different. Ms. Sidgwick, am I getting that right? And if so, can you just explain what the two different data sets would be? I'm picking you up right on that.
Indeed, the SG, which is document CD 3.2 on pages 7 and 8, contains a number of plans or maps that form the spatial framework. The spatial framework sits on page 8. On page 7, we see, as I understand it, what makes up the red and the green that we see on the spatial framework contained in picture 3. My reading of it is that the area of peat, or the area of red within which a lot of the Arecleoch extension site sits, is red, and that is as a result of the peat which is shown in blue on the map on the bottom left of picture 2, which is on page 7. We undertook an SPP review of it, and that area of peat doesn't sort of tick the SPP bits of peat as I understand it, and that's the essential difference. But Mr. McGibbon may be able to provide more information.
Okay, thank you. Mr. McGibbon, can you help us on that point?
Yeah, what I would say is that the mapping in the SG, that's a strategic document and it's at a very high scale. So I think it's about 1 to 25,000. So it's not intended to be used as the basis of the protection. It's quite difficult to tell from that plan, from that drawing or map, what areas within protection and what's not. So it's more a strategic map as opposed to a detailed map. So I think that's where, obviously, this basis map, the strategic map, has been used by the applicants to produce a further map, which then shows that the wind farm's out with the area of protection. But as I say, I don't think you can't use that strategic map for the basis of that purpose. What I say as well is that the council didn't raise an objection in regards to peat. So yeah, that'd be the council's point on that issue.
The point I would draw from that is that essentially the site is a Group 3 site in terms of SPP and its locational advice, which is still very relevant.
Is somebody speaking?
Sorry, that was my fault. I was speaking, but I was muted, so apologies. That's fine. If we can move on then to item 13, which is supplementary guidance, dark sky lighting. And Mr. McGibbon's hearing statement refers to this. Again, we don't have any questions, but I just wanted to give Ms. Sidgwick the chance to respond to that hearing statement if she wanted to. But again, bearing in mind we've got an upcoming inquiry session on landscape and visual effects, so if it's something that we pick up then that's fine.
Indeed, sir. It's the impact on the dark sky will be considered at the landscape and visual session, and Mr. Welsh will present evidence on behalf of Scottish Power at that stage.
Okay, that's fine. Thank you. So, if we can move on to number 14, which is about the South Ayrshire wind landscape capacity study. So let me just explain the background to this. I probably could have expressed that question better. So the supplementary guidance, as we understand it, that was adopted in December 2015. The supplementary guidance on wind energy, that's CD 3.2, and it was based, or is based, on the 2013 South Ayrshire wind capacity study, which is CD 6.34. So what we're really interested in is whether there are significant differences between the 2013 South Ayrshire wind capacity study and the 2018 update of it in terms of landscape character type categorisation affecting the site and the surrounding area. And as far as we can see, both documents show the site within character type 18C, with the land to the northeast and the northwest along the Stincher Valley and the Dewis Valley identified as character type 13, intimate pastoral valleys. And the implications of this is for the landscape and visual impact inquiry. But I suppose just for today, Mr. McGibbon, if you confirm to us that both documents are similar, then that's probably sufficient, or very similar. But if it's something that you're not in a position to comment on today, we can pick it up at the inquiry session if that's easier. But we didn't see any great difference between the 2013 and the 2018 versions of the study as far as that site is concerned. I just want to clarify that point.
There's no difference between the sites, but what I'd say is obviously I've just got a kind of statement here. If you the supplementary guidance on wind energy, as you say, was issued in 2015, and that was informed by the 2013 landscape wind capacity study. Obviously, that wind capacity study updated was issued in 2018. The supplementary guidance on wind energy therefore needs updating in relation to where the 2013 capacity study is noted, although the landscape and visual information set out in much of the SG is broad in nature and also accords with the 2018 capacity study, which I think is the crux of your question. And this is demonstrated in pages 11 and 19 of the SG, where the broad principles in relation to key landscape and visual sensitivities and cumulative effects have been informed by the 2013 capacity study. And again, this has not changed in the updated 2018 study. The main body of the SG provides strategic guidance, information on potential constraints.
Mr. McGibbon, I fear the reporters may be having trouble keeping up with you at this speed. Sir, I'm not sure how you want to deal with this, but there's quite a lot of detailed information about the alteration between the various iterations of the document. Would it help you to have a note?
Yeah, I mean, essentially the crux of it comes down to the 2018 capacity study looks at very large turbines, which are over 130 metres. So that's kind of updated, and it also looks at the cumulative baseline as well. So that's been updated, because essentially the 2013 study concluded sensitivity for large turbines greater than 70 metres would be medium low, whereas the 2018 capacity study has found that this has increased to high medium to very large turbines over 130. So I think that the crux of it is essentially as the new wind capacity studies take into consideration these larger turbines, because that wasn't considered in 2013. But certainly the landscape character types are unaltered, is my understanding, and it's essentially to change to take into the larger turbines. As I say, the wind energy supplementary guidance will be updated in due course.
Sorry, if
I'm happy to provide a note of this as well.
I think that's probably fine. That the assessments are different in terms of sensitivity, because the second one treats with the possibility of larger turbines, if you like, that the first one doesn't envisage so much. I think, and if that's the main point, then I think that's probably enough for us. Unless Alison, have you got any questions on this at this point?
No, I think that's useful clarifications for now. I think we can pick it up at the inquiry for the landscape and visual impact. I think that's where the implications of those differences may need to be looked at in more detail.
Very well. We'll try and go over it a bit more slowly in that session, so that you have a note of all those changes. I was just conscious Mr. McGibbon was going quite fast, and it might be difficult for you to keep up. But if you were keeping up, then good.
Yes, thank you. I think as far as today is concerned, we've got what we need on that. Okay. 15. Just a minor point about the modified proposed LDP. Nobody's really taken us to that. It's seemingly not materially different in terms of its policies. So my question was just for information, Mr. McGibbon, do you know when the likely submission date is for the examination? Just okay.
Yeah, the council submitted the letter of examination on the 14th of December last year, so that process started.
Okay, thank you. Okay, so item 16 then is on social economics, and we refer there to Mr. Kelly's statement that the net economic impact assessment required by SPP has not been addressed. Now we've touched upon this point already insofar as the view from Mr. Kelly and others about the relevance of constraint payments and contracts for difference and that kind of financial side of it. But I just want to give you the chance, Mr. Kelly, to just kind of take us through this line of argument or summarise your position if you wanted to.
Thank you, sir. It's a remarkably simple concept. The bullet point the first bullet point in paragraph 169 of SPP2 starts off with the word net. To reach a net conclusion on economic impact, you need to identify and cost all of the negative externalities, as economists would call them, as well as the asserted benefits. And it's a perfectly relatively straightforward exercise to do. As far as I'm aware, all of the negative externalities all have assessment methodologies associated with them that ultimately allow you to come to a view on a cost factor. So I think what we tend to see in the economic impact assessments for wind farms is 99% focus on the positives or the claimed positives and not a proper net economic impact assessment. In setting out my point, I don't presume what the outcome will be in any particular case because you have to do the calculations. But what I do say is looking at the economic impact material for this application, the applicant's consultants have not sought to identify all the negative externalities and cost them. It's a straightforward economic impact exercise to get the net effect. And the crucial thing is that SPP says net, not just the positives, the net.
Okay, thank you. When you say negative externalities, what I don't need an exhaustive list, but what are the main kind of things that you're thinking of there?
You have the economic externalities. I mean, is there any loss of tourism revenue? Is there economic activity diverted to the wind farm that would otherwise take place and be more beneficial? You can cost loss of amenity. You can cost the loss of peat or peat quality. You can even cost the loss of landscape value. These are all perfectly straightforward economic impact assessment techniques that are currently available. So the role, in my view, the role of the assessor, the objective assessor carrying out a net economic impact assessment is to look at their particular application and reasonably consider what are the negative externalities. Now, you can include constraints payments in that, and you can make an assumption, and make it quite clear that it's an assumption, and then factor it into the calculation. It's not a difficult exercise for an experienced economist to do, just that the applicants don't do it.
Okay, that's fine, and yeah, you're telling us that paragraph 169 that all the requirement to do all that flows from what's said there in paragraph 169 about net. Ms. Sidgwick or Mr. Ernest, indeed, do you want to respond to that?
Yes, thank you. I'm not aware of the sort of assessment that Mr. Kelly's suggesting having been undertaken in respect of a wind farm. I'm not aware of assessments, for example, of the sort of financial values associated with the loss of landscape and things. I personally haven't come across an assessment of the sort that Mr. Kelly is talking about. I've been involved in quite a lot of wind farms over the last 15 or so years. And I'm not aware of one. If you can point me in the direction of one, I would be happy to take a look at it. the EIA process has got a socio-economic chapter. It has looked at the potential for the loss of tourism and the like, and it, to the best of my knowledge, there isn't evidence that suggests that tourism is negatively affected by the presence of onshore wind turbines. There's been quite a lot of research over a number of years on it, and that is set out in the relevant chapter of the EIA, which I think is chapter 14, and that includes the Moffat report, the Hutton report, and the bigger report of 2017. There is also the BVG report, which is document CD11, which looks at the economic benefits associated with some of the work Scottish Power has done in the southwest of Scotland. And I don't think I have anything else to say on the matter.
Can I jump in, sir? Because Ms. Sedgwick has just confirmed my point. Like her, I've never seen this done. I've never seen a net economic impact assessment carried out by a wind farm applicant, but paragraph 169, first bullet point, is perfectly clear. It couldn't be clearer. It may help you, sir, if I give you just take a couple of sentences to explain the history here. Prior to the release of SPP2 in 2014, I attended a ministerial seminar, and I think it was Fergus Ewing that was speaking, and he stressed at the seminar that he wanted to see the economic effects of wind farms given greater weight in decision making. And therefore he said, he gave a preview that SPP2 would include this word net, this requirement to assess net economic impact. Now at the seminar, I actually asked them, said, Minister, are you sure you want to include the word net? And I then explained to him my understanding of what net meant. And he said he did, and lo and behold, we have it here. I can't see how you can escape it. It says net economic impact, which means identifying and costing all the negatives as well as the potential benefits of the scheme. But as Ms. Sedgwick and I are in agreement, I've never seen it done.
Well, that's fine, because I was going to ask you the question, have you seen it done? And if it's never been done, by consequence, no reporter or no minister in making a decision has ever judged it when needed to have been done.
No minister has made that judgment, but are you saying because it's inconvenient, we have to ignore this bullet point? I don't think that's how planning policy works.
Okay, no, I'm not saying anything. Just asking the questions. Mr. Bacope, you had your hand up there, I think.
I just wondered if I might add a few remarks on these topics from a local perspective. First of all, reinforcing the point that the construction phase of wind farms is where you get the employment. That tends to be about 18 months, after which it's really nothing. It's just sort of a few maintenance vans for 10 years. And a lot of these people, come up from around Aberdeen anyway. And as far as the construction phase is concerned, all locals know that the bulk of people working on these projects either come from elsewhere in the UK, or particularly with Scottish Power renewables projects. Of course, many of them come from Spain and Portugal. And local contractors who get involved in these projects, particularly big projects like Arecleoch, they have to gear up for participating in these projects. In other words, invest in many more machines and lorries and whatnot. And of course, once the project is finished, they then have that, the loans of all that equipment they have to service. So they then become cross-Scotland companies. They're sort of semi kind of national, as it were, rather than local. So they're not really any longer local jobs, actually. As far as employment is concerned, I'm frankly pretty sceptical about that. And as far as the other effects on tourism, for example, we have for a long time had things like fishing, game fishing, and sort of deer stalking and whatnot as being sort of quite important little things which contribute towards local hotels, etc., kind of catering for these people. The deer stalkers by and large have gone now because they just simply don't like going through forests with wind farms all through them. So that's gone now. So we don't. Currently our hotel is not in operation. So we don't have the benefit of that kind of income. But in general terms, one might observe that people who drive over the top of the moor and then are confronted by the great wall of turbines on the opposite side of the valley. Most of the time, you're not particularly gripped by that sight. Actually, I think that translates into kind of tourism and sort of day trips and whatnot. People enjoying the landscape. The Luce Valley is now a landscape with lots of wind turbines in it, and I think the majority of people don't enjoy that. And I think that my sort of moving on possibly to topic 17, I would just ask a general question. All these studies done, investigating tourism with respect to wind farms, you can't help noticing that across Scotland, in the kind of iconic landscapes of the Highlands and islands and wherever, and this is leaving national parks to one side, you can't help noticing that where you have these iconic landscapes, you tend not to have any turbines. So someone somewhere must appreciate that there's a link between tourism value and having lots of wind farms. I mean, driving across Scotland, whenever you do that, you can't avoid that observation. So, this is what Scotland is famed for. And if you go and put loads of wind farms in it, then obviously you damage that. So I'm not gripped by these reports of studies done which show no effect on tourism. Frankly, I just don't believe it. Really. So I hope that answers sort of Alison Sidgwick's case there, because I really don't agree with it at all, frankly. Anyway, that's what I wanted to say on that.
Okay, no, that's fine, Mr. Buckhook. Yeah, I mean, we're going into item 17, but that's fine. Let's consider these socio-economic things together because they are related. I'm going to obviously go back to Ms. Sidgwick to see if she wants to respond to these points. But do any other of the objectors want to speak on this issue? Ms. McDade, I think, do you want to come
in? Yes, if we're, hang on. Yes, if we're moving on to item 17, I've just got a couple of quick points which relate to what Mr. Buckhook actually just said and what Ms. Sidgwick also referred to. There is actually evidence that people do not like wind farms, even in the Moffat report. So that is CD 13.1, the Glasgow Caledonian report, which is also called the Moffat report. 2008 study was done. And they did interview people in Stirling before Braes of Doon was up, before there were actually a wind farm there. But within that study, they did find something like, people prepared something like at that time, about £6 a night extra for a view out of a B&B that was not of a wind farm. So actually, even back then, when there was much smaller and much less development of wind farms, that was clear. And in fact, in that study, again, there was a comment which reflects what Mr. Buckhook just said, that it said it may well, there are people who, and I'm paraphrasing, I haven't had time to look this up, but I certainly can if it's required. There are people who will not like to visit areas of wind farms, and it may be that there should be areas protected for natural environment. So that was back in 2008, which is really a different country in terms of what we're looking at here, with the size of wind turbines here, phenomenal size, and that wasn't considered back then. And the other two studies, the next two studies quoted by Scottish Power 2012, which again was not really related to anything like what we're talking about here. We do not have a good study of what people would think of 200-metre high turbines because they have not been put up on land. So the most recent one is the Bigger Economics study. The Bigger Economics study, which is CD 13.5, has a lot of flaws. And again, this wasn't part of my remit, so I haven't got it to hand, although we could put it in a closing submission. But amongst what was there was they looked at areas with wind farms which are not looked on as scenic areas, such as around Methil in Fife. So it was not a clear study of what we're talking about in this area of people coming to visit natural environment. So that's the point I'd like to make about those studies. Thank you.
Okay, thank you very much. Is there anything else from any of the objectors before I go back to the applicant? Mr. Andrews, did you have your hand? Yeah, apologies.
Yes, thank you. I accept refutation of my concerns about of the application on tourism in the village of Bar Hill and the locality. Because each individual place has singular and particular aspects. I would also draw the attention of the inquiry to the earlier discussion about grid connection, which Mr. Innes described, connecting to Mark Hill substation, which requires crossing the village of Bar Hill, either within or just without the village bounds. Now, it seems quite incredible, but it's true that, that this will be on overhead power lines. Now, if this is not, if that does not actually have a visual impact on the potential tourist trade, I think it probably is really not acceptable for the applicant to continue to refute the impact that the application is certainly going to have here. Thank you.
Okay, thank you. Are there any other points from objectors before I go back to Ms. Sidgwick? Okay then, Ms. Sidgwick, is there anything else you want to add?
Yes, please, if I could just address a number of points. My understanding is that Scottish Power do indeed have locally staffed operational compounds associated with some of their sites, including in the southwest of Scotland. I understand Whiteley has certainly has locally staffed compound areas. Just going on to the comment about parts of the Highlands and Islands not having wind farms. There are, of course, in some of these parts of the world, NSAs which have the same level of protection as national parks, sort of sitting as they do in the Group 1 part of the SPP table on locational information. I'm certainly not trying to make the case that all people like wind turbines. I know that they are a Marmite type factor, and there are certainly people who dislike, and I would accept that there are some people who would perhaps choose not to go to an area because of wind turbines. but the published evidence out there indicates that there is no impact on tourism as a result of wind turbines. Yes, some of the studies are dated, but there has been nothing more recent to say that there is an issue and that there is a negative impact resulting. Document CD 7.6 notes that on page 6 in the first bullet point that support for renewable energy continues to increase. I'm not suggesting that that means that that's just focused with wind turbines, but the principle of renewable energy is being increasingly supported by the British public. And as I say, there's no impact of them being negatively impact to the best of my knowledge. And finally, my understanding is that the connection into the Mark Hill substation is likely to be undergrounded.
Okay, thank you. Ms McDade.
If you asked anybody here whether they support renewable energy, we probably all would tick yes. You know, there is renewable energy and there's renewable energy. We're probably all thinking, can I get a wood burner or, you know, a pump or whatever. So that study, you know, about most people support renewables does not address this particular area and the issue of tourism in this area. And it is just not correct that there's no evidence that people do not like it. There was a very extensive study by the Cairngorm National Park Authority, Loch Lomond and Trossachs and Scottish Natural Heritage on what people thought about impacts on wildland characteristics. And top of the list of what they didn't like was power lines, and wind farms were also in there as infrastructure. So that document's not lodged, but I can't let that statement go past without saying it's just untrue to say there is no evidence. Yes, there is.
So, could I just ask a question? You worked for the John Muir Trust, didn't you, Helen McDade? I can't see it. So I wanted to know, I think the John Muir Trust was involved in some questions surrounding Ben Nevis, the Ben Nevis area. And there were some questions of turbines to do with the aluminium park plant there. I wanted to know what the outcome of that particular kind of project and you know, what the trust thought about that.
Can I intervene, Mr. Buckhook? I'm just wondering. I can confirm that Ms. McDade did work for John Muir Trust. Why is that? Why is that example relevant to us? Can I just finish? I'm just concerned about bringing in, without any prior knowledge or prior warning, evidence about a completely different case. I don't want anyone to be disadvantaged. Right. But I mean, I'll let Ms. McDade answer the question if she wants to. But I'm just put that caveat on it about.
Okay, I'm sorry. You know, that is you know, another context completely, and perhaps it's inappropriate. But you know, it just struck me that, you know, that was you know, a wind turbine project where tourism was potentially substantially impacted. That's really why I raised it, you know, in relation to the other remarks that I'd made. So, I mean, I just, you know, if she would like to, that's fine. If not, I'm content with that.
Can I just clarify? Yeah, I'm not here representing the John Muir Trust. And so I wouldn't like to speak on their behalf anyway. They're not a party in this. But also, I think, if I understand what you're referring to, it happened after I was there anyway. So I don't have anything I would want to say on that particular issue. Thanks.
Okay, thank you. Without wanting to cut anyone off, I'm content that we've covered sufficiently people's people with the chance to say what they wanted to on social economics, including tourism. So I was proposing just to move on to the final item of the agenda, if that's okay for everyone. And so some of the hearing statements cover landscape and visual effects, wildland, private water supplies, and we'll come on to those in the relevant topics. But I just wanted to give you all the chance at the end of the hearing just to say if there's anything that you want to say that you haven't had the chance to say, or by way of a wrap up in relation to the policy related matters we've been discussing today. And as I say, there's no need to repeat what you've said already or what you've put in writing, but it's just if there's any final points to be made. So in no particular order, Mr. McGibbon for the council, have you anything else to say?
Nothing new, but I just stress that the council are not against renewable energy, certainly not. And as I say, we've certainly not objected to other examples. It's just we feel this is not the right development in the right place.
Can I take it so that you're going to deal with questions of residential amenity so far as they arise from policy questions? Can I take it you're going to deal with those in the landscape and visual session? Sorry, inquiry session.
Yeah, I think that's how I was thinking it would work. I'm just looking to Alison to see if she's going to nod her head to say so as well. But
yeah, well, in terms of visual amenity, it would be dealt with in that session. Obviously, noise amenity would be the session for that, and
yes,
amenity.
It's just Mr. McGibbon in his inquiry report, or in his hearing statement, he does have a session at 4.5, 4.6 about residential amenity, and it picks it up again at 4.10. Obviously, it's there for you to read, but and you haven't touched on it today. So I think it could probably quite usefully be brought into the landscape and visual session in part 2 of the inquiry.
okay, well that's fine. We can you can draw attention to that if we're not taking to it. Mr. Buckock, are there any final comments that you want to make?
I can't think of any at the moment. No. I think I probably said all the things that I wanted to say. So, what I will do is follow up some of the points I've made on a final statement. So, if anybody wanted more information about some of the remarks I've made, I will include those in that. So, I think I'll just leave it at that, if that's all right.
Yeah, yes, that's fine, and that's probably a good reminder. What we'll do at the end of all the inquiry hearing sessions is, I think we'll just give everyone the chance to make a closing statement, if you like. And how it would tend to work is that the council and the objectors would go first, and then the applicant would be invited to make their closing submissions 2 weeks after that or something. But we'll confirm the arrangements for that at the end of the session. There's no need to do anything in the meantime. Mr. Kelly, have you got anything to say at the end?
Yes, thanks, sir. I may well have some policy comments to make on these other topics, but first I need to hear the evidence. So I'll have to wait to the closing submission, since we're having this session before the evidence. So I'll wait till I hear the evidence and decide. Thank you.
Okay, thank you. And Ms. McDade?
No further comments. Thanks for that.
Okay, and Mr. Andrews, anything else from you?
Thank you. No, I have really no extra points to make. But if I may, on tourism, that the admission that that overhead power lines are now likely to be undergrounded appears to be an admission by the applicant that there is an impact on tourism of wind farms and associated infrastructure. So, it is quite difficult, really, after a year or two of this, refuting the impact on tourism, to admit there is. But in any case, I'm glad it now has come out in this inquiry, and thank you.
Okay, thank you. And finally then, Ms. Sidgwick, is there any final remarks you want to make?
No, sir, we have no further remarks on the topics raised today. I have one procedural matter I'd like to raise later, but you may want to formally close the session today before doing that, if I may.
Okay, okay, that's fine. Thank you very much. Well, okay, I just want to thank you all then for your contributions today, and for some of you for forbearing the connection issues. But certainly, I think we've heard everything we needed to hear. So I'll close this session now and formally end this hearing. We are convening again tomorrow, or some of us are with others. But I'll just go back to Mr. Innes at that point then. What was the point you wanted to raise?
Yeah, yes, sir. It's in relation to wind farm lighting. The applicants have lodged a document CD 1526, which is a report relating to aviation lighting. The technical and visual aspects of aviation lighting are all dealt with by Mr. Welsh in his inquiry report, and obviously will be dealt with in his precognition. We, as the applicant, have also proposed a condition 5 on aviation lighting, and insofar as there was commentary raised in the response to the questions, that any questions you have on the condition might be dealt with by landscape and visual at the landscape and visual impact inquiry session. It wasn't my intention or our intention to have the two people who'd be able to answer any questions that you'd have on the technical aspects and the deliverability. And I was going to suggest that it may be more appropriate that they were available when we discussed condition 5 at the conditions session. And if you had any questions about the deliverability ultimately of the matters set out in the Cirrus report, that might be the appropriate time in which to have that discussion. Mr. Welsh, of course, will deal with all the technical aspects of aviation lighting and the potential impacts, dealing with the worst case scenario and the potential mitigations that are available. But if it's on those aspects and the deliverability of the condition, I was proposing to bring those responsible. I've got potentially an internal person from Scottish Power and a technical consultant who are far better equipped to be able to respond to any questions on those matters. But I was just going to seek confirmation that would be the appropriate time for them to come along. It's just there's a lot of parties appearing at the landscape and visual session, and it is an inquiry session. So I just paused to propose that particular timetabling.
Okay, thank you. I'm going to see what if Alison's got a view of that, but that seems perfectly fine for my part.
Yeah, that seems fine. I mean, it will just, if the matter comes up during the inquiry, then you can remind us that we're going to deal with that at the conditions.
If necessary, we can have Miss Anderson attend that session for the discussion of that draft condition. That's the landscape consultant, sir. You're frowning, but
no. No, I'm grateful for that, Mr. Campbell. That's helpful. Okay, so for those of us that are participating tomorrow, it's a 10 AM start with a 9:45 log on, if you like. But otherwise, I'd just like again to say thank you very much for your participation, and I'll formally end the meeting. Thank you.
Sorry, can I just remind everybody that deadline for a list of documents 5 p.m. tonight for tomorrow's session. Thank you.
Sorry, I didn't hear you there. You froze. What? I didn't hear what you said. I'm sorry.
Right, just a reminder that for those that are attending tomorrow, the deadline for the list of document references is 5 p.m. tonight.
Yeah, right.
Okay, thank you.
Thank you.